ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಅಲ್ಲಿ ಫೋಸ್ಕೋ ಇದೆ, ಕಂಪ್ಲೇಂಟ್ ನೋಟಿಸ್ ಹಾಕ್ಬೇಕು, ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕಾ? ಮಾಡ್ತೀರಾ ಮೇಡಮ್? ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ನೋಟಿಸ್ ಹಾಕ್ಬೇಕು, ಫೋಸ್ಕೋ ಇದೆ ಸೆಕ್ಷನ್. ಮೇಡಮ್ ಕೋರ್ಟಲ್ ಅದೇ 15 ಕಂಪ್ಲೇಂಟ್ ನೋಟಿಸ್ ಆಗ್ಬೇಕು ಮೇಡಮ್, ಮತ್ತೆ ಅಷ್ಟೇ, ನಮ್ದೇನಿಲ್ಲ. ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಯಾವುದು 34 parted matter. Parted matter. Parted matter. What is the inconvenience? Counsel, parted matter. When do you want? Huh? No, 15 days, 438 petitions. Settling that. Petitioner counsel seeks time on the ground that matter is going and seeks time, and hence this matter. First of August. First year operate 53 year. Huh? What is the inconvenience? Huh? convenience. Huh? Did not. I'll post this matter on Friday. This matter on Friday. Friday is madam to 22nd. Order sheet and ಕೇಳಿತ್ತಲ್ಲ. This matter on 22nd. 22nd post ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಅಲ್ಲ. ಸರಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 50. ಹಾ ಹೇಳಿ. ಅದ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಅದಕ್ಕೆ ಟೈಮ್ ತಗೊಂಡಿದ್ರಿ. ಹಾ ಅದಕ್ಕೇನ ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ. ಹಾ ಯಾವ್ದು ಬೇಕು? ನಾಳೆ ನಾಡ್ದ ಯಾವ್ದು ಬೇಕು ಹೇಳಿ. Day after tomorrow. ಆಯ್ತು. Petitioner counsel 6 time this matter day after tomorrow. ಯಾವ್ದು ಮೇಡಮ್? 20th. 20th. 54 to 58 ಯಾರು ಇಲ್ಲ. Patraj B. Serial number 1. Serial number 1. Petitioner counsel absent, 1 week time granted. This is checked. Petitioner counsel submits that the petitioner seeks oral permission to convert the petition as as appeal, and hence permitted to convert the same as appeal. For the statistical purpose, criminal petition is disposed of. T. Prakash. Petitioner counsel seeks 1 week time granted as well. I don't know whether we are relying upon those documents or whether those documents are legible. Just the office objections. Only one. Only one, madam. ಏನು ಗೂಗಲ್ ಏನಾರು ಇದೆಯಾ? ಎಸ್ಸಿಟಿ ಇದೆಯಾ? ಎಲ್ಲ ಯಾಕೆ ಬೇಕು? 58 ಇದೆ. ಎಲ್ಲ ಎಲಿಜಿಬಲ್ ಇದೆಯಲ್ಲ? ಆಫೀಸ್ ಆಯ್ತು ಓದಿರ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಟ್ ರೌಂಡ್ ಎಷ್ಟು ಮಂಟೆಗೆ ಎಷ್ಟು ಮೇಡಮ್? ಸಿಕ್ತಲ್ಲ. ಬಾಲಕೃಷ್ಣನ್ ಎಸ್ ಬಾಲಕೃಷ್ಣನ್ ನಾಟ್ ಫೈಲಿಂಗ್ ಅಪ್ ವಕಾಲತ್. ಅಪ್ಲೈ ಮಾಡಿ ವಕಾಲತ್ ಹಾಕಿ. ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ on 11th of July. ಬೇರೆ ಏನಾರು ಇದೆಯಾ? ವಕಾಲತ್ ವಾಸ್ ಫೈಲ್ಡ್. ನಿನ್ನೆ ಅಲ್ಲ ವಕಾಲತ್ ಹಾಕ್ಬೇಕೀಗ. ಹಾಕಿದೀರಾ? ಆಯ್ತು ಫೈಲ್ಡ್ ಅಂಡ್ ಹೆನ್ಸ್ HGP ತಗೊಳ್ಳಿ. And hence and in view of compliance, HGP is directed to file take notice and file objections if any. This matter on 25th. Third time GV Manjunatha. Petitioner counsel absent, 1 week time granted on payment of cost of ₹500 payable at registry. This matter on 26th. If not complied and cost not paid. Javed, Henry Javed. Counsel submits that during the course of the day he will comply with office objection and hence urgent on cost of ₹500 payable at registry. Dilraj, Jude Rohit.
A week's time may be granted, my lord. Certified copies are not ready.
Cost of ₹500 payable at registry.
Please, my
Granted.
lord.
Yes. Yes, Balakrishnan. Same, week's time granted on cost of ₹500 payable at registry. Fourth time. Mahadevaya. Petitioner counsel is absent and hence and this matter is listed for 4th time for non-compliance and hence adjourned on cost of ₹1,000 payable at registry. And if office objections not complied and cost not paid, list this matter on 26th ಕೊಡಿ. ಹಾಕಿದೀವಾ? ಮತ್ತೆ ಕಾಸ್ಟ್ ಕಟ್ಟಿದಾರಾ? ಮತ್ತೆ ಯಾಕೆ ನೋಟ್ ತೋರಿಸಿಲ್ಲ ಇದರಲ್ಲಿ? ಕಾಸ್ಟ್ ಇಸ್ ನಾಟ್ ಫ್ರೀಡ್ ಇಟ್ಟಿರಾಗಾರೆ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ ಮೋಸ್ಟ್ಲಿ ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರ್ಬೋದು. ಸೀರಿಯಲ್ ನಂಬರ್ 11 to 25. Serial number 11 to 25.
My lordship, serial number 15, my lordship.
All matters in 11 to 25, HCGP is directed to take notice and file objections if any. Any notice?
Serial number 15 ಅಲ್ಲಿ ಇದೆ.
15 or 16. 15, 16, 20. Date ಬೇರೆ 28 ಕೊಡು. 25th or 27th ಕೊಡು. ಯಾವ 20th? ಅಲ್ಲ ಯಾವ್ದು ಅಷ್ಟು 15, 16, 20 ಎಲ್ಲ 27th. ಯಾಕೆಂದ್ರೆ ನೋಟಿಸ್ ಜಾರಿ ಆಗ್ಬೇಕು. ಆಯ್ತಾ? HCGP is directed to notify the complainant oblique victim and informant. ಅಷ್ಟೇನಾ? Shorter date is next Monday, 25th. ಎಲ್ಲ 25th ಕಾಮನ್ ಡೇಟ್ ಎಲ್ಲದಕ್ಕೂ 25th. 26 to 32 any notice?
27 and 29.
27 and 29 ಸೇಮ್ ಆರ್ಡರ್ ಮೇಡಮ್. 27 and 29 ಪೋಕ್ಸೋ ಮ್ಯಾಟರ್ ನಲ್ಲಿ 27th ಡೇಟ್, 27th ಡೇಟ್. ಬಾಕಿದೆಲ್ಲ 25th. 25th ಮಂಡೇ, ನೆಕ್ಸ್ಟ್ ಮಂಡೇ. Parted in orders. ಶಂಕರಪ್ಪ. Genealogical tree because ಏನೋ some relationship ಏನೋ ಹೇಳ್ತಾ ಇದ್ರು ಅವ್ರೇನೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ಕೆ ಪಾಸ್ವರ್ಡ್. ಮೂರ್ತಿ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನಾಯ್ತು ಬಂತ? A2 and A3 ಇದು A2 and A3 1 and second one are ಏನಿದ್ರು 3 is grievous in nature, 1 and 2 are simple in nature. 3 ano what is that? 3 fracture of left distal ಏನ್ರಿ ಓದಿರ ನೀವು? ಕಷ್ಟ ಆಯ್ತು. ಡಿಸ್ಟಲ್ 1/3 ಇರ್ಬೇಕು ಆಫ್ ರೈಟ್ ಥೈನಾ ಏನದು? ಏನೇ ಈಸ್ ಔಟ್ ಆಫ್ ಡೇಂಜರ್ ಅಲ್ವಾ? ವೆನ್ ಹಿ ವಾಸ್ ಡಿಸ್ಚಾರ್ಜ್ ಎನಿ ಇನ್ಫಾರ್ಮೇಶನ್?
ಡಿಸ್ಚಾರ್ಜ್ ಆಲ್ರೆಡಿ ಅವರು ನಿಮಾನ್ಸ್ ಅಲ್ಲಿ 4 days ಇದ್ದ.
ನಿಮಾನ್ಸ್ ನಲ್ಲಿ
ಒನ್ ಮೋರ್ ವಿಕ್ಟಿಮ್ ಇಸ್
ಇನ್ನೊಬ್ರದ್ದು ಇದೆಯಾ? ಅವ್ರದ್ದು ಯಾವ್ದೋ ಒಂದು 1 and 2 are grievous. Pelvic region measuring 8 into 1 centimeter size. Fracture of right parietal bone. So pain right in a fracture of bony in the night. Assaulted with what is the weapon, madam? That is parietal region. Talage hodididane. It is vital part on the body. Or maybe out of danger, but he inflicted injury on the vital part of the body. Maybe discharged, madam. Maybe discharged, but the injuries are grievous in nature, and that too a fracture on the parietal bone, as well as brain injury. Maybe brain injury. Just how long he was in the hospital? Maybe out of danger, madam. We should see the. Madam, vital part. This is a petition under section 438. What about A1? Granted bail by regular 439 or 438? 439. Accused number 4.
What act by this petitioners?
Hmm?
A2 and A3. What
A2
act-
and A3 only by vote act. But no vote act allegation against the mother. Huh? Instigation, but instigation is different from inflicting of injury. No antecedents are not necessary. 438 petition. You see, what is the allegation against him? These two, A2 and A3. ಮಕ್ಕಳಾದ ರಕ್ಷಿತ್ ಮತ್ತು ದೀಕ್ಷಿತ್ ಇವರು ತಂದೆ ನಾಗರಾಜ್ ಅವರು ನಮ್ಮಗಳನ್ನು ಏಕಾಏಕಿ ಅಡ್ಡಗಟ್ಟಿದ್ದರು. ಆಗ ನಾನು ಮತ್ತು ಮಂಜು ಅವರು ಬೊಲೆರೋ ವಾಹನದ ಕೆಳಗಿಳಿದಾಗ ದೀಕ್ಷಿತ್ ತನ್ನ ಕೈಯಲ್ಲಿದ್ದ ದೊಣ್ಣೆಯಿಂದ ತನ್ನ ತಲೆಗೆ ಮತ್ತು ಎಡಕೈಗೆ ಮಾರಣಾಂತಿಕವಾಗಿ ಹಲ್ಲೆ ಮಾಡಿದನು. ಆಗ ನನ್ನ ತಲೆಯಿಂದ ರಕ್ತ ಹರಿದು ಬಂದಾಗ ನನ್ನ ತಮ್ಮ ಯಾಕೆ ನಮ್ಮ ಅಣ್ಣನಿಗೆ ಹೊಡೆಯುತ್ತೆ ಎಂದು ಬಿಡಿಸಲು ಬಂದಾಗ ರಕ್ಷಿತನು ನೀನು ಈತನ ಸಪೋರ್ಟ್ಗೆ ಬರ್ತಿದೀಯ, ನಿನ್ನ ಮುಗಿಸುತ್ತೇನೆ ಎಂದು ತನ್ನ ಕೈಯಲ್ಲಿದ್ದ ಮಚ್ಚಿನಿಂದ ಮಂಜುವಿಗೆ ತಲೆಗೆ ಮಾರಣಾಂತಿಕ ಹಲ್ಲೆ ಮಾಡಿದನು. ದೀಕ್ಷನು ಅದೇ ದೊಣ್ಣೆ ತನ್ನ ತಮ್ಮ ಮಂಜನ ತಲೆಗೆ ಬಲಗೈಗೆ ಹೊಡೆದು ಅಲ್ಲ ಇದ್ದ ನಾಗರಾಜ ಸುಮ್ಮನೆ ಬಿಡಬೇಡ ಸಾಯಿಸಿ ಅಂತ ಕುಮ್ಮಕ್ಕು ನೀಡಿದಳು. ನಂತರ ನಮಗೆ ತೀವ್ರ ಪೆಟ್ಟಾಕಿದ್ರಿಂದ ಅಲ್ಲಿದ್ದ ಗಲಾಟೆ ವಿಚಾರವನ್ನು ಸುಧಾ ನಮ್ಮ ಭಾವನ ಮುಟ್ಟಿಸಿದಾಗ ಹೆಡ್ ಇಂಜುರಿ ದಿನೇಶ್ ಇದೇನಿದು ಫ್ರಾಕ್ಚರ್ ಆಫ್ ಲೆಫ್ಟ್ ಡಿಸ್ಟಲ್ 1/3 ಆಫ್ ರೈಟ್ ಏನ್ರಿ ಅದು ರೈಟ್ ಟೈಲ್ 3
Yes.
ಟಿಬಿಯನ್ ಅಲ್ಲ ಟಿ ಹೆಚ್ ಏನ ಇದೆ ಟಿಬಿಆರ್ ಹೆಚ್ ಬರಲ್ಲ ಅಲ್ಲಿ ಏನಂತ ಹೇಳ್ತಾರೆ. ಹೌ ಲಾಂಗ್ ದೇ ವರ್ ಇನ್ ಹಾಸ್ಪಿಟಲ್?
ಅದೇ injury for 4 days.
ಹಾ
ಇಲ್ಲಿ before that they are in Mandya
ಹಾಸ್ಪಿಟಲ್.
ಹೌದು.
both are from Madduru. The wound certificate was given at Madduru.
Initially they have taken treatment. From there they had gone to KIMS Mandya. From there they had referred to Imans.
Defect fracture of right parietal bone. Right forearm. Fracture of both bone is fracture of both bones. One and two are previous in nature. Imans, how long they were there in the hospital? 4 days.
4 days.
Imans. So, what are the petitioner's counsel and also the counsel, petitioner counsel and also the counsel appearing for the state? The factual matters of the case of the prosecution is that there was a dispute with regard to the flow of water and when the complainant questioned the same, galata was taken place. And the incident was taken place on 30/4/2022. It is also alleged in the complaint that on 2/5/22, in the early morning at 10 a.m., when the injured Manju was coming after unloading tender coconut, these two petitioners along with their parents wrongfully restrained him. When the complainant and the victim Manju alighted from the Bolero vehicle, at that time, the second petitioner inflicted injury with the club on his head and also to his left hand. And blood was oozing from his head. And when the complainant intervened to pacify the incident and to rescue his brother, immediately the first petitioner with the machete inflicted injury on his head. The first petitioner also with the very same club inflicted injury on his head and also right hand and thigh and also backside the neck. The same was witnessed by one Nagraj who was there along with them, also abused in a threatened, also instigated, and mother also instigated not to leave them. The incident was pacified by Chandrasekhar and Shankarana. The injured persons were taken to immediately in the very same vehicle to Madhur Hospital and also shifted to Mandya Hospital. The counsel appearing for the petitioner would submit that the trial court already granted bail in favor of other accused number 4 in criminal misdemeanors number 458 of 2022. And counsel also would submit that A1 already enlarged on bail under section 438 of CRPC. The counsel also would submit that these two petitioners are the children of accused number 1 and 4, and the injured persons are out of danger and they may be enlarged on bail. The counsel also would submit that the court has to take note of under which circumstances an incident was taken place and there was no any prior enmity. Only quarrel is with regard to the trivial matter of flow of water, and hence they may be enlarged on bail. For contrary, the counsel appearing for the state would submit that specific Vote Act allegation is made against these two petitioners. These two petitioners wrongfully restrained the victims and they came with machete and club and inflicted injury on the vital part of the head. As a result, both of them have sustained previous injuries. Merely because they were discharged from the hospital is not a ground. The court has to take note of the gravity of the offense, and the petition is filed under 438 of CRPC. Having heard the respective counsel and also on perusal of material, specific Vote Act allegation is made against these two petitioners that they went with machete and also club and inflicted injury on the head. There was a fracture of left distal 1/3 and also fracture of both bones. And there were 2 injured persons. No doubt both the injured are discharged from the hospital and they took treatment at Madhur Hospital, thereafter at District Hospital, and one among them was shifted to Nimans, wherein also he was treated for 4 days. Having taken note of nature of injuries are grievous in nature, however, Court has to take into note of the circumstances under which the incident was taking place, and the incident is also with regard to flow of water. There was a quarrel on 30/4/2022, and again this incident was taken place on 2/5/2022. And prior to that, there was no any ill will or motive. Under the circumstances, when the injured persons are out of danger, it is a fit case to exercise the powers of the creator CRPC with conditions.
My lord, serial number 34. I'm sorry, my lords. I'm not sure whether the matter was called, my lords.
34 was earlier moved for an adjournment.
I'm sorry, my lords. I was not informed about the adjournment.
So you are appearing for respondent.
Yes, my lords.
Complainant.
Complainant.
They took time on the ground that there is a likelihood of settlement.
No, my lords. On the last occasion also, they made a submission. My lords gave them time till today to pay back 78 lakh rupees. Not a single phone call or any kind of communication was made with us.
88 lakhs for having paid the amount. That is subsequently very same property was sold. Anyhow,
Yes,
I have given the date on 1st of August. Parted matter.
Please, my
Parted
lords.
matter.
Please, my lords. Oblige,
Yes.
my lords.
Please, Your Honor.
56. FSL last time in FSL cause of ಏನಾಯ್ತ್ರಿ ಬಂತ cause of the body was decomposed. Like, what is the material now? Case is rest upon the circumstantial evidence. Final opinion. The examination from autopsy findings report the cause of death of the cause also is undetermined.
But there is no eyewitness, my lord. Then no motive to kill, my lord. Delay in filing the complaint, my lord.
Delay ಎಷ್ಟು sir?
5/12/2021 is said to be, my lord, date of murder.
5/12?
2021, my lord.
21.
11/1/2022 is the date of complaint.
11/1.
Please, my lord. And no missing complaint has been filed. As you rightly by this honorable court, only on circumstantial evidence, my lord, they are linking.
What is the chain of circumstances?
CDR report. CDR report. Mobile.
CDR report. What CDR report says?
Brother mobile ಅವಳಿ ಕೊಟ್ಟಿದ್ದಾಳೆ ಅಂತ. ಸಾರಿ, ಅಕ್ಯೂಸ್ ಮೊಬೈಲ್ ಅನ್ನು ಅವಳಿ ಕೊಟ್ಟಿದ್ದಾಳೆ ಅಂತ, ಬ್ರದರ್ ಮೊಬೈಲ್ ಅನ್ನು ಇವನು ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ ಅಂತ.
ಇವನು ಬ್ರದರ್ ಮೊಬೈಲ್ ನಿಂದ ಕಾಲ್ ಮಾಡಿದಾನೆ ಆಕೆಗೆ, ಬಟ್ ಹಿಸ್ ಮೊಬೈಲ್ ವಾಸ್ ವಿತ್ ಹಿಮ್, ವಾಸ್ ವಿತ್ ಹರ್. CW 19 statement recorded, and he says that his mobile was used by his brother anta.
That particular time, CDR report, both also had gone to the accused mobile.
Brother mobile ಇಂದ ಅವನಿಗೆ ಆಕೆ ಮೊಬೈಲ್, ಆಕೆ ಕಸ್ಟಡಿ ಇದ್ದಂತ ಮೊಬೈಲ್ ಅಲ್ಲಿ ಬಾಡಿ ಎಲ್ಲಿ ಸಿಕ್ಕಿದ್ದು? ಬಾಡಿ ಫೋನ್
kindly see the body, my lord, after ಏನು ಅಂತ ಗೊತ್ತಾಗಲ್ಲ.
ಬಾಡಿ ಬೇಡ, ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಬಾಡಿ ವೇರ್ ದೇ ಫೌಂಡ್ ದಿ ಬಾಡಿ. ಜೋಳದ ಮಧ್ಯದಲ್ಲಿ ಇತ್ತು. ಆಯ್ತು, ಈ CDR ಲೊಕೇಶನ್ ಎಲ್ಲಿದೆ? ಆಕೆ ತೀರ್ಕೊಂಡ್ಲಲ್ಲ, ಆ ಜಾಗದಲ್ಲಿ ಇದೆಯಾ ಲೊಕೇಶನ್? ಸ್ಪಾಟ್. ಈ ಮೊಬೈಲ್ ಯಾರ ಕಡೆಯಿಂದ ಸೀಸ್ ಆಯ್ತು? ಈ ಮೊಬೈಲ್ ಆಕೆ ಹತ್ರ ಇತ್ತು, ಇವನ್ ಮೊಬೈಲ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಅಕ್ಯೂಸ್ ಇಂದಲೇ ಸೀಸ್ ಆಗಿದ್ಯಾ? ಇನ್ಸ್ಟೆನ್ಸ್ ಆಫ್ ಪಿಟಿಷನರ್ ಲೊಕೇಶನ್ ಹೇಳಿ. ಎರಡು ಮೊಬೈಲ್ಗೆ ಎಷ್ಟೊತ್ತಿಗೆ ಆಗಿದೆ ಫೋನ್ ಅವತ್ತು?
ಕರೆಕ್ಟ್ ಆಗಿ ಅವ್ರು ನೋಡಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವರು ತಾಯಿ ಅವರು ಇದಕ್ಕೆ ಹೋದಾಗ ವಿದೇಶಕ್ಕೆ ಹೋಗ್ತಾರೆ ಅವರು ಆ ಚಂಬು ಹಿಡ್ಕೊಂಡು ಆ ಲೇಡಿ
ಒಂದ್ ಲೇಡಿ ಒಬ್ರು ಹೋಗ್ತಾರೆ.
ನೋಡಿದ್ರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವಾಗ ಆ ಟೈಮ್ ಹೋದ್ರು ಅಂತ
ಅವ್ರು ಯಾರು ಅದು CWS ಅವರು
ಕಂಪ್ಲೇಂಟ್ ಮದರ್
ಕಂಪ್ಲೇನೆಂಟ್. She is the mother of the victim. What is the motive for committing the murder?
The deceased and the accused having illicit relationship. Both of them, as per the prosecution, she is threatening to get married another girl of this issue. And this accused, and she decided to eliminate her. ಈಗ ಬಿಟ್ಟು ಹುಡುಗಿನ ಹೇಳ್ಕೊಂಡ್ಬಂದು ಇದು ಮಾಡ್ತಾಳೆ ಅದನ್ನ ಮದುವೆ ಮಾಡಕ್ ಬಿಡಲ್ಲ.
ಇಬ್ಬರದು ಮದುವೆ ಆಗಿಲ್ವಾ?
ಅವ್ರ ಮದುವೆ ಆಗಿ ಗಂಡನಿರೋದು.
ಏಜ್ ಡಿಫರೆನ್ಸ್ ಏನೋ ಹೇಳಿದ್ರಿ ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ 29 ಅಲ್ಲ? ಅಲ್ಲ, ಬಟ್ ಲೊಕೇಶನ್ ಎಲ್ಲಿದೆ ಹೇಳಿ. CDR ರಿಪೋರ್ಟ್ ಪ್ರಕಾರ ವೇರ್ ದಿ ಬಾಡಿ ವಾಸ್ ಫೌಂಡ್, ವೆದರ್ ದಿ ಲೊಕೇಶನ್
ಹೌದು, ಅದೇ ಊರಲ್ಲಿ ಲೊಕೇಶನ್ ಇದೆ.
ಊರಲ್ಲ,
ಸಿದ್ದಾಪುರ. ಅದು ಟವರ್ ಅಲ್ಲಿ ಮಾತ್ರ ತೋರಿಸ್ತಾ ಇದೆ.
ಅವನಲ್ಲಿ ತೋರಿಸುತ್ತೆ. ಅವ್ನ ಬ್ರದರ್ ಫೋನ್ ಯೂಸ್ ಮಾಡಿದಾನಲ್ಲ, ಅದರಲ್ಲಿ
ಸಿದ್ದಾಪುರ ಗ್ರಾಮದ ಹತ್ತಿರ ಫೋನ್ ಮಾಡಿ ಗ್ರಾಮದ ಹತ್ತಿರ ಇರೋ ಅದೆರಡು ಆ ಲೊಕೇಶನ್ ಅಲ್ಲೇ ತೋರಿಸ್ತಾ ಮನೆ ಇದೆ.
ಎರಡು ಒಂದೇ ಲೊಕೇಶನ್ ತೋರಿಸ್ತಾ ಇದೆಯಾ? ಎರಡೂ ನಂಬರು. ಆಕೆ ಹತ್ರ ಆ ಫೋನ್ ಎಷ್ಟು ಟೈಮ್ ಇಂದ ಇದೆ?
ಅವನೇ ಹಾಕೊಂಡಿರ್ಬೇಕು.
ಅಲ್ಲ, ಆಲ್ಮೋಸ್ಟ್ ಬಾಡಿ ಯಾವಾಗ ಸಿಕ್ಕಿದ್ದು? 5/12/21 ಬಾಡಿ ವಾಸ್ ಫೌಂಡ್ ಆನ್
17
ಆ ಮಂತೇನೆ. ಅವಾಗ ಏನ್ ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ?
ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿಲ್ಲ. 11/1
ಇಲ್ಲ.
17 ಅಲ್ಲಿ ಬಾಡಿ ಮೌಂಟ್ ಆಗ 5/12 ಇನ್ಸಿಡೆಂಟ್
ಆಯ್ತು. 11/1 ವರೆಗೂ ಏನು ಅನುಮಾನ ಇಲ್ಲ, ಏನಿಲ್ಲ. ಈಗ ರಿಯಲಿ ಏನಂದ್ರೆ
ಅಲ್ಲಿ ವಿಚಾರಿಸಿದಾಗ ಅವರಿಬ್ರು ಅನೈತಿಕ ಸಂಬಂಧ ಇದ್ದಿದ್ದರಿಂದ ಇವನು ಮಾಡಿದಾನೆ ಅನ್ನೋದು ಗೊತ್ತಾಯ್ತು ಅಂತ ಹೇಳಿ ಅವಾಗ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ ಅವನ ಮೇಲೆ. ಪೂರ ವಿಚಾರಿಸಿದಾಗ ಹಿಂಗಿತ್ತು ಅಂತ, ಅವನೇ ಮಾಡಿರ್ಬೋದು ಅಂತ ಕಂಪ್ಲೇಂಟ್. ಅದ್ರ ಬೇಸ್ ಮೇಲೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗುತ್ತೆ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ CDR ರಿಪೋರ್ಟ್ ಆಮೇಲೆ
ಯಾವಾಗ ಅರೆಸ್ಟ್ ಆಗಿದ್ದು?
12/1
11th ಕಂಪ್ಲೇಂಟ್, 12/1 ಅರೆಸ್ಟ್. Heard the petitioner, counsel and also the counsel appearing for the state. Charge sheet ಆಗಿದೆಯಲ್ಲ? The factual matters of the case of the prosecution is that the marriage of the victim was solemnized in 2018 and her husband was passed away. And thereafter she came and settled in her parental house. The further case of the prosecution that this petitioner was having an illicit relationship with the victim and he had purchased a SIM and given the handset to her. When the same comes to the knowledge of the villagers, this petitioner planned to eliminate the victim. But on 5/12/21, he used the two-wheeler, went to the Guru Siddhapura, and by using his brother mobile, called her near the land of Ch-17. And quarreled with her and assaulted her. When she fell down, he committed the murder using the towel, strangulated her. The counsel appearing to the petitioner would submit that the alleged murder was on 5/12/2021 and body was found on 17/12/21. Till 11th of January 2021, no complaint was given. The counsel also would submit that no missing complaint was also found. The case is rest upon the circumstantial evidence, and in order to connect the petitioner, no material is collected by the prosecution. The counsel also would submit that in terms of the FSL report, the cause of death is also not determinable. And hence, and this petitioner is in custody from 12/1/21, almost from last 1.5 years. 22 months, 2022 now.
Complaint 11 months.
From last 7 months. And no need of further custody and trial, and hence petitioner may be enlarged on bail. For contrary, the counsel appearing for the state would submit that this petitioner has given the mobile to the victim, and on the date of incident, that is on 5/12/21, he called her through the mobile of his brother. The statement of his brother, that is CW19, also recorded with regard to using of his phone by this petitioner. The counsel also would submit that the tower location also discloses the place of incident, and both the mobiles are used in the same location. The counsel would submit that the very same mobile which was used by the victim was seized at the instance of this petitioner. There is a prima facie material to connect the petitioner, and there is a sound circumstances against the petitioner. Having heard the respective counsel and also on perusal of material, the alleged incident was taken place on 5/12/21. The body was also found almost after 13 days of the alleged murder. No complaint was given even after the body was found. And complaint was given on 11/1/21. Sorry, 22, 11/1/22. And this petitioner was arrested on the next day. That is almost 1 month, 6 days of the alleged murder. The prosecution mainly relies upon the CDR report. And body was also decomposed, and cause of death is also not determinable. And the only circumstances to connect the petitioner is CDR. It is also important to note that the phone which was seized from the petitioner belongs to him only. And also allegation that to said mobile, this petitioner called through the mobile belongs to his brother. Having taken note of this material available on record, first of all, the cause of death is also not determinable. And also only based on the statement of CW 119 that this mobile has been used. And apart from that, mobile seized is also standing in the name of the petitioner only. Hence, it is a fit case to exercise a discretion in favor of the petitioner. And the investigation already been completed and charge sheet is also filed, and no missing complaint was filed immediately after the body was found, and only after that, after 1 month, 6 days of the alleged murder, the complaint was given. Hence, it requires full-fledged trial and no need of further custodial trial. You have the discussions made up. I pass the word. Their petition is with conditions. ಹಾಕಿದಾರ Petitioner counsel has filed memo for withdrawal of the petition has not pressed. Who of the filing of memo permitted to withdraw and dismissed as not pressed. 38 Ganesha K.
Case of Dina speaks, my lord. Your lordship has already granted bail. Even ground that there is no proximity and
Cause of death.
excess.
Where is that order?
I have
What is the relationship between A2 and the victim?
there is no relationship, my lord. They are supposed to be real estate agents. A1 has transferred his father's site to the victim's name and through that borrowed money from the bank and not facilitated the repayment of the loan. Actually, loan is borrowed by the victim himself. The allegation is that by transferring his property, father's property, they have cheated by not repaying the loan.
This appears this is regular bail. Earlier granted is only a regular bail. Now you are seeking for an anticipatory bail. What is the allegation? What is the allegation against you?
That he was with the A1. The main allegation is against A1. And this man was also there with A1. That is the allegation.
Convince obtain loan. Convince obtaining loan. A1 and A2 both approached deceased. And they will make repayment.
Actually, who availed the loan? Accused number 2 antide. You are A2.
The loan is taken in the name of the victim.
The name of the victim.
On the site which is in his name.
Right.
Which is supposed to have been transferred by A1 to the victim.
Complainant's name.
For the purpose of taking loan.
The loan was obtained. The name of complainant.
Complainant ಹೆಸರಲ್ಲಿ loan ತಗೊಂಡು.
Complainant husband na friendship ಮಾಡ್ಕೊಂಡು
Loan was taken in the name of complainant.
Complainant.
These accused number 1 and 2. Complainant is the wife of victim. Wife of the victim.
Wife of the victim. The loan is taken in the name of the victim.
Loan taken in the name of victim only. How much amount they have taken?
What the lakhs, my lord?
40 lakh.
Actually,
ಯೋಗಾನಂದ ಸ್ವಾಮಿ ಕಿರುಕುಳ ನೀಡಿ ಸಾವಿಗೆ ಪ್ರಚೋದನೆ ನೀಡಿ ನನ್ನ ಗಂಡನ ಸಾವಿಗೆ ಕಾರಣರಾಗಿರುವ ಮೊದಲ ತಾರತಮ್ಯ.
Actually, the utterances, the words are said by A1 when victim went to demand repayment.
And 3 days after that, he has committed suicide.
I will go through the content. 3 ತಿಂಗಳ ವಾಸ ಮಾಡಿಕೊಂಡು ಜೀವನ ಮಾಡಿಕೊಂಡಿರುತ್ತೇವೆ. ನನ್ನ ಪತಿ ಅವರು ಆಟೋ ರಿಕ್ಷಾ ಚಾಲನೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ನನಗೆ 16 ವರ್ಷದ ಲಕ್ಷಿತ ಮಗಳಿರುತ್ತಾರೆ. ನನ್ನ ಪತಿಯವರು ಹಿಂದೆ ಶೂ ಫ್ಯಾಕ್ಟರಿಯ ಜಾಬ್ ವರ್ಕ್ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. ನನ್ನ ಪತಿಗೆ ನಲಗದರಹಳ್ಳಿಯ ವಾಸಿ ಮಂಜುನಾಥ್ ಆರಾಧ್ಯ ಮತ್ತು ಅವರ ಸ್ನೇಹಿತ ಶ್ರೀನಾಥ್ ಬಾಬು ಎಂಬುವರು ಪರಿಚಯಿಸಲಾಗಿದ್ದು ರಿಯಲ್ ಎಸ್ಟೇಟ್ ವ್ಯವಹಾರ ಮಾಡುತ್ತಿದ್ದರು. ನನ್ನ ಪತಿ ಇವರೊಂದಿಗೆ ಓಡಾಡಿಕೊಂಡಿದ್ದು ನಂತರದಲ್ಲಿ ಫ್ಯಾಕ್ಟರಿಯನ್ನು ಸಹ ಮುಚ್ಚಿದರು. ಹೀಗೆ ಸುಮಾರು 4 ವರ್ಷಗಳ ಹಿಂದೆ ನನ್ನ ಪತಿಯು ನನಗೆ ತಿಳಿಸಿದ್ದೇನೆಂದರೆ ಮಂಜುನಾಥ್ ಆರಾಧ್ಯರವರು ಅವರ ತಂದೆ ಹೆಸರಿನಲ್ಲಿ ವಿದ್ಯಾರಣ್ಯಪುರ ಬಳಿಯ ಸಂಭ್ರಮ್ ಕಾಲೇಜ್ ಹತ್ತಿರ ಇರುವ ಸೈಟ್ ಅನ್ನು ನನ್ನ ಹೆಸರಿಗೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸಿಕೊಟ್ಟಿದ್ದು, ಈ ಸೈಟ್ ಅನ್ನು ಜಾಲಹಳ್ಳಿ ಕ್ರಾಸ್ ನಲ್ಲಿರುವ ಯಶಸ್ವಿನಿ ಮಹಿಳಾ ಕೋಆಪರೇಟಿವ್ ಬ್ಯಾಂಕಿನಲ್ಲಿ ಅಡಮಾನ ಬಿಟ್ಟು ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ಸಾಲ ತೆಗೆದುಕೊಂಡು ಈ ಹಣವನ್ನು ಮಂಜುನಾಥ್ ಆರಾಧ್ಯ ಮತ್ತು ಶ್ರೀನಾಥ್ ಬಾಬು ಅವರು ಪಡೆದುಕೊಂಡು ಬಿಸ್ನೆಸ್ ಮೇಲೆ ಇನ್ವೆಸ್ಟ್ ಮಾಡಿ ಲಾಭ ಮಾಡಿ ನನಗೂ ಹಣ ಕೊಡುತ್ತೇನೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ನಮ್ಮ ಕಷ್ಟಗಳು ತಿಳಿಸುತ್ತಾರೆ ಎಂದು ಬ್ಯಾಂಕಿಗೆ ಬಂದು ಸಹಿ ಮಾಡುವಂತೆ ತಿಳಿಸಿದರು. ನಾನು ನನ್ನ ಗಂಡನಿಗೆ ಇವೆಲ್ಲ ನಮಗೆ ಯಾಕೆ ಇರುವುದೆಲ್ಲ ಗೊತ್ತಿದ್ದೇವೆ, ಈ ಸಾಲದ ಪ್ರತಿಸಾದ ನಮಗೆ ಬೇಡ ಎಂದು ನಿರಾಕರಿಸಿದ್ದೇನೆ. ಮಂಜುನಾಥ್ ಆರಾಧ್ಯ ಮತ್ತು ಶ್ರೀನಾಥ್ ಅವರು ನಮ್ಮ ಮನೆಗೆ ಬಂದು ನನ್ನೊಂದಿಗೆ ಮಾತನಾಡಿ ನೀವು ಬ್ಯಾಂಕಿಗೆ ಬಂದು ಸಹಿ ಮಾಡಿದ ನಿಮ್ಮ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಕೊಡ್ತೇವೆ ಎಂದು ಹೇಳಿ ಸಹಿ ಮಾಡಿದರು. ನಾನು ನನ್ನ ಗಂಡ ಒತ್ತಾಯಕ್ಕೆ ಮನೆಗೆ ನಮ್ಮ ಹೆಸರಿನಲ್ಲಿ ಸಾಲ ಪಡೆಯಲು ಒಪ್ಪಿದೆವು. ಬ್ಯಾಂಕ್ ಅಧಿಕಾರಿಗಳ ಜೊತೆ ಮಾತನಾಡಿ ದಾಖಲಾತಿಗಳ ಮೇಲೆ ನಮ್ಮ ಸಹಿ ಪಡೆದರು. ಹಣ ಜಮೆ ಆಯ್ತು. ನಿಮ್ಮ ಅಕೌಂಟಿಗೆ ದುಡ್ಡು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆಯಾ? ನಂತರ ಈ ಹಣವನ್ನು ಅವರುಗಳ ನನ್ನ ಖಾತೆಗೆ ಅವರ ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿಕೊಂಡರು. ಇದಾದ ನಂತರ ಮಂಜುನಾಥ್ ಆರಾಧ್ಯ ಮತ್ತು ಶ್ರೀನಾಥ್ ಬಾಬುರವರು ಮೊದಲು ಬ್ಯಾಂಕ್ನ ಸಾಲದ ಹಣವನ್ನು ಕಟ್ಟುತ್ತಿದ್ದರು. ಕೆಲವು ತಿಂಗಳ ನಂತರ ಹಣ ಕಟ್ಟೋದನ್ನು ನಿಲ್ಲಿಸಿದರು. ಆಗ ಬ್ಯಾಂಕ್ ಅಧಿಕಾರಿ ನನ್ನ ಗಂಡನಿಗೆ ಫೋನ್ ಮಾಡಿ ಸಾಲದ ಹಣವನ್ನು ಕಟ್ಟಿ ಎಂದು ಹೇಳುತ್ತಿದ್ದರು ಮತ್ತು ನೋಟಿಸ್ಗಳನ್ನು ಸಹ ನಮಗೆ ಕಳಿಸಿದ್ರು. ನನ್ನ ಗಂಡ ಈ ವಿಷಯವನ್ನು ಮಂಜುನಾಥ್ ಆರಾಧ್ಯ ಅವರ ಸಾಲದ ಹಣವನ್ನು ಏನ್ರಿ ಅಮೌಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಅವ್ರ ಅಕೌಂಟ್ಗೆ? ದಾಖಲೆ ಇದೆಯಾ? ಗಾಡಿ ಆಟೋ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದು ಇದರಿಂದ ಬರುತ್ತಿದ್ದ ಹಣ ನಮ್ಮ ಜೀವನ ಸಾಕಾಗುತ್ತೆ. ನಮ್ಮ ಮಗಳು SLC ವ್ಯಾಸಂಗ ಮಾಡ್ತೀವಿ. ಇದಕ್ಕೆ ಭವಿಷ್ಯದ ಬಗ್ಗೆ ಯೋಚನೆ ಮಾಡಿ ನನ್ನ ಗಂಡ ಮರ್ಯಾದೆಗೆ ಹಂಚಿ ಸರಿಯಾಗಿ ಮನೆಗೆ ಬಾರದು ರಸ್ತೆಯಲ್ಲಿ ಅಲ್ಲಿ ಮನೆಕೊಂಡು ಕಾಲ ಕಳೆದಿದ್ರು. ಮನೆ ಮುಂದೆ ಆಟೋ ನಿಲ್ಲಿಸಿಕೊಂಡು ಅಲ್ಲಿ ಮಲಗುತ್ತಿತ್ತು. ಮಂಜುನಾಥ್ ಆರಾಧ್ಯ ಕ್ಲಿಯರ್ ಮಾಡಿ ಕೊಡುತ್ತೇನೆ. ಆಗ ನನ್ನ ಗಂಡನ ಮೇಲೆ ಕೇಸ್ ಆದರೆ ನಾನು ಜೈಲಿಗೆ ಬಿಡಿಸಿಕೊಂಡು ಬರುತ್ತೇನೆ ಎಂದು ಒತ್ತಾಯಿಸಿ. ಒಂದ್ ನಿಮಿಷ ಇರ್ರಿ.
Even if allegation is true also, it's a question, maybe a question of cheating, but it will not become 306. The words uttered by that is A1, not even A2, is that I don't care even if you die. And 3 days later, he commits suicide. There is no connection between the utterance of the words and the commission of the suicide. And therefore, 306 is not attracted. And your lordship has already come to that conclusion in the previous bail. Specifically on that ground, the bail has been done.
That is 439, right? 438 or 439?
Principle will apply to
President of Cooperative Society with a condition cooperative responses also issued from the occurrence. Sorry, madam. Order the petitioner counsel and also the counsel appointed by the state. The factual matters of the case of the prosecution is that this petitioner and accused number 1 for having acquaintance with the husband of the complainant. And accused number 1 and this petitioner, both of them have persuaded the husband of the complainant to get the loan from the cooperative society And even though the complainant refused to sign the papers, persuaded her also to sign the papers. And after availing the loan, amount got transferred to the account of the accused number 1, but they did not repay the amount. Then bank started issuing notice against the husband of the complainant, and the complainant and her husband requested to make the payment. And in spite of request, they did not heed to their advice. On 25/4/22, the husband of the complainant went near the house of accused number 1, saying that he will go and talk to him regarding loan amount, but he did not return. And phone was also switched off. That on 27/4/22, the complainant went near the house of accused number 1. On inquiry, he replied that her husband was not visited the house and abused her. That on 28/4/2022, some unknown persons called the complainant and informed that her husband committed suicide in Krishnappa layout. And immediately she rushed to the spot and found the body. And an allegation is made that this petitioner and accused number 1, who have availed the loan, did not repay the amount, and hence he took a extreme step of committing the suicide. The counsel appearing for the petitioner would submit that he left the house on 25/4/22 and body was found on 28/4/22. And there is no any nexus between the cause of death and taking extreme step of committing suicide by the husband of complainant. The counsel also would submit that this court already granted bail in favor of accused number 1 and 3. 1 and 3. 1 matra na to? 1 and 3. 1 and 3. ಇಲ್ಲ ರೀ, ಇಬ್ರು 4 ಜನ ಇದಾರಲ್ಲ. 1, 3 and 4 in criminal petition number 4505 of 22, 4479 of 2022, wherein this court also observed that whether it attracts section 306 or not is a matter of trial. And also courts would see that whether there must be an excess and proximity to the cause of death and enlarged on bail. For count of the counsel appearing for the state would submit that specific allegation is made against this petitioner and also accused number 1. But both of them have persuaded in getting the loan, and they did not repay the amount. The counsel also would submit that this court granted bail invoking section 439 in respect of the accused number 1. And granted anticipatory bail in respect of other accused. Since the court found that the notice has been issued on section 41A of CRPC, wherein it is stated with regard to conducting of the measure in respect of availing of the loan, and there is an apprehension of arrest. Having heard the respective counsel and also on perusal of material, so specific allegation is made against this petitioner and case number 1 that both of them have persuaded the husband of complainant in getting the loan. And on perusal of the contents of the complaint, after sanction of loan, the amount was transferred in favor of the accused number 1. That is 40 lakhs, which was sanctioned in favor of sanctioned from the SSVini Cooperative Bank. And both of them were making payment at the first instance and thereafter stopped making payment. making of repayment. Having taken note of the said fact into consideration, amount was also transferred in favor of accused number 1 account, and he has already been enlarged on bail by this court. And only allegation against this petitioner is that he persuaded along with accused number 1 in getting the loan. And also he left the house on 25/4 and body was found on 28/4. When suspending the material, it is appropriate to invoke 438 of CRPC with a condition to cooperate with IO for investigation. Order sheet ಏನೋ ಕೊಡ್ಬೇಕು ಹೇಳಿ.
ಪ್ರೊಕ್ಲಮೇಷನ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಸಮನ್ಸ್ ಸರ್ವಾಗಿಲ್ಲ. ಇದರಲ್ಲಿ ಪ್ರೊಕ್ಲಮೇಷನ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
ಏನು 438 ಇದೆ?
438. ಅಫೆನ್ಸ್ ಪನಿಷಬಲ್ ಅಂಡರ್ ಸೆಕ್ಷನ್
419 420. ದಿನಾಂಕ 17/7/2001 ಫಿರ್ಯಾದಿಯು ಮೇಲ್ಕಂಡ ಆರೋಪಿಗಳಿಂದ ಸುತ್ತಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 158 ಕಾರಣ 4 ಗುಂಟೆ ಜಮೀನನ್ನು ಪರಿಸ್ಥಿತಿ ಮುಂಗಡವಾಗಿ 3 ಕಾಯ್ದ ಪತ್ರವನ್ನು ನೋಂದಣಿ ಮಾಡಿಸಿಕೊಂಡಿದ್ದು ದಿನಾಂಕ 27/5/2001 ಮೇಲ್ಕಂಡ ಆರೋಪಿ ಜಮೀನಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ದಾಖಲೆಗಳನ್ನು ನೀಡದೆ ನೋಂದಣಿಯನ್ನು ಮಾಡಿಸಿಕೊಳ್ಳದ ಅನುಮಾನವನ್ನು ನೋಡಲಾಗಿದೆ. Allegation against you that you already sold the property in 2010 itself.
ಮಾರಾಟ ಆಗಿದೆ, ಆ ಪ್ರಾಪರ್ಟಿ ಸಂಬಂಧಪಟ್ಟ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಡ್ತಾರೆ.
Then how you executed one more sale agreement in favor of the complainant on 17 to 2011.
11 ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್. 15/3/2010 ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
Earlier. Prior to that there was a sale in favor of one Murthy.
ಅದರಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಬರ್ಕೊಟ್ಟಿರೋದು ಸರ್ವೆ ನಂಬರ್ 158 ಗೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ 23 ಗುಂಟೆ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ.
158/2.
ಇದು 158/2 ಬಂದು 11 ಗುಂಟೆಗೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ.
ನಿಮ್ದು ಮೊದಲು ಬರ್ಕೊಟ್ಟಿರೋದು ಎಷ್ಟು?
23 ಗುಂಟೆಗೆ ಸರ್ವೆ ನಂಬರ್ 158 ರಲ್ಲಿ 23 ಗುಂಟೆಗೆ.
ಆಯ್ತು, ಅದೆಷ್ಟು ಸರ್ವೆ ನಂಬರ್ 158?
158 ಸರ್.
158 ಸರಿ ರೀ, 2 ಪ್ರಾಪರ್ಟಿ ಇದೆಯಾ?
ಅದು ಅದ್ರ ಬಗ್ಗೆ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನು
ಕೊಡಿ, ನೀವು ಕೊಡಿ, ಹೋಗ್ಲಿ ನೀವು ಕೊಡಿ, ಈಗ ತೋರಿಸಿ.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ
ನೀವು ವೆರಿ ಸೇಮ್ ಪ್ರಾಪರ್ಟಿ, ಹೌ ಯು ಹ್ಯಾವ್ ಸೋಲ್ಡ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಇನ್ ಫೇವರ್ ಆಫ್ ಹಿಮ್?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಎಷ್ಟೇ
ಆಯ್ತು ಈಗ 11 ಗುಂಟ ಮತ್ತೆ ನೀವೇನು 23 ಗುಂಟೆ ಹೇಳ್ತಿರಲ್ಲ, ವೆದರ್ ದೋಸ್ ಪ್ರಾಪರ್ಟೀಸ್ ಆರ್ ಡಿಸ್ಟಿಂಕ್ಟ್ ಪ್ರಾಪರ್ಟೀಸ್? ಅಲ್ಲ ರೀ, ಒಂದ್ ಪ್ರಾಪರ್ಟಿ ಮಾರಾಟ ಮಾಡಿ ಮತ್ತೆ ಹಂಗೆ ನೀವು ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಡ್ತೀರಿ, ದುಡ್ಡು ತಗೊಳ್ತೀರಿ.
ಅದರಲ್ಲಿ ಇವರನ್ನ ಕೈಂಡ್ಲಿ ಮೈ ಲ್ಯಾಪ್ಟಾಪ್ ಮೈ ಕೈಂಡ್ಲಿ ಪೇಜ್ ನಂಬರ್ 29 ಮೇಲೆ ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ದಿ ಸೇಲ್ ಡೀಡ್ ಮೇಲೆ.
ಪೇಜ್ ನಂಬರ್ 29.
ಈಗ ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಇದೆ.
ಈಗ ಕೊಟ್ಟಿರೋದು ಪೇಜ್ ನಂಬರ್ 29 ಹೇಳಿ.
ಅದರಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 158 23 ಗುಂಟೆ ಪೂರ ಜಮೀನು ಅಂತ ಇದೆ. ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಸೈಡ್ ಡೀಡ್
29 ಅಲ್ಲಿ
ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ನಂದಿ ಹೋಬಳಿ ಕುಪ್ಪಳ್ಳಿ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ 158 23 ಗುಂಟೆ ಜಮೀನಿಗೆ ಪೂರ ಚೆಕ್ ಬಂದಿದೆ.
ಆಯ್ತು, 158 23 ಗುಂಟೆ ಪೂರಾ ಜಮೀನಿಗೆ ಚೆಕ್ ಬಂದು ನಿಂತಿದೆ 158. ಆಯ್ತು, ಈಗ ನೀವು ಮತ್ತೊಂದು ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಟ್ರಲ್ಲ. ಆಯ್ತು, 2 ಗೆ ಸೆಪರೇಟ್ ಪ್ರಾಪರ್ಟಿ ಇದೆ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ಹಾಕಿದ್ರಿ ದಾಖಲೆ ಇದೆಯಾ? ಪಾಣಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಆರ್ಟಿಸಿ ಅಲ್ಲಿ
ಎಲ್ಲಿದೆ ಆರ್ಟಿಸಿ?
ಪೇಜ್ ನಂಬರ್ 39 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
39 38. ಸರ್ವೆ ನಂಬರ್ 158 ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿ 150 ಬೈ ಹಿಸ್ಸಾ 2 ಇದೆ, 11 ಗುಂಟಾಸ್ ಇದೆ. ಆಯ್ತು, ಅದೆಲ್ಲಿದೆ 158 ಇದು ಹಿಸ್ಸಾ 2 ನೇ ಇದೆಯಲ್ಲ, ಇನ್ನೊಂದು 11 ಗುಂಟೆ 23 ಗುಂಟೆದು ಅದು ಹಿಸ್ಸಾ 2 ನೇ ಇದೆ.
ಅದು ಹಿಸ್ಸಾ ಇಲ್ಲ ಸರ್,
ನೋಡಿ ನಿಮ್ದೇ ಡಾಕ್ಯುಮೆಂಟ್ ನೋಡಿ 41 ಅಲ್ಲಿ.
ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್
ಅಲ್ಲಿ 158 ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರಿ.
158 ಅಂತ
ಮತ್ ನಿಮ್ ಪ್ರಾಣಿ ಪ್ರಕಾರ 158/2 ನೇ ಇದೆ ಹಿಸ್ಸಾ. 23 ಗುಂಟನೇ ಇದೆ.
158/2
ವಾಂಟ್ ಸಿ ಕೌನ್ಸಿಲ್ ಪೇಜ್ ಪಾರ್ಟಿಗೆ ಹೋಗಿ 23 ಗುಂಟೆ ಎಷ್ಟರಲ್ಲಿ ಇದೆ ರೀ? ಪೇಜ್ ನಂಬರ್ 41 ಅಲ್ಲಿ ನೋಡಿ.
41 ನಲ್ಲಿ 158
ಹಿಸ್ಸಾ ಎಷ್ಟು?
ಹಿಸ್ಸಾ ಇಲ್ಲ ಸಮಯದಲ್ಲಿ.
ಹಿಸ್ಸಾ ಇದೆಯಲ್ರಿ? 2 ಹಿಸ್ಸಾ ಅಂತ ಇದೆಯಲ್ರಿ?
41 ನಲ್ಲಿ ಇಲ್ಲ ಸರ್.
ಏನ್
ಆರ್ಟಿಸಿ ಅಲ್ಲಿ 41 ಅಲ್ಲಿ ಹಿಸ್ಸಾ ಇಲ್ಲ ಸರ್.
ಕದಿರ ಮೇಸ್ತ್ರಿ ಬಿನ್ ಮುನಿಶಾಮಪ್ಪ ಅಂತ ಐತಲ್ರಿ?
ಹೌದೌದು ಸರ್. ಕದ್ರಿ ಮೇಸ್ತ್ರಿ ಮುನಿಶಾಮಪ್ಪ 11 ಗುಂಟೆ, ಕೆ ಮುನಿಕೃಷ್ಣ 12 ಗುಂಟೆ. ಅದ್ರಲ್ಲಿ ಹಿಸ್ಸಾ ಇಲ್ಲ ಸ್ವಾಮಿ. 158 ಮಾತ್ರ ಇದೆ ಸರ್.
152 ಹಿಸ್ಸಾ ಅಂತ ಇದೆಯಲ್ರಿ ಇಲ್ಲಿ? ನೀವೇ ಕೊಟ್ಟಿರೋದು ಪ್ರಾಣಿ ಕೊಡ್ರಿ ತೋರ್ಸ್ರಿ.
158/2
158 ಹಿಸ್ಸಾ 2 ಅಂತ ಇದೆ ನೋಡಿ. 23 ಗುಂಟೆ.
1 ಗುಂಟೆ ಖರಾಬ್ ಇದೆ.
1 ಗುಂಟೆ ಖರಾಬ್ ಇದೆ, ಅದ್ರಲ್ಲೇ ಹಿಸ್ಸಾ 2 ಅಂತ ಇದೆ ನೋಡಿ. ಎರಡು ಅಂತ ಇಲ್ಲ ಅಲ್ರಿ ಮುಂದ್ಗಡೆ? ಕಾಲಮ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಅದು ಹಿಸ್ಸಾ ಬರೋದು. ಹಳೆದ್ರಲ್ಲೂ ಅದೇ ಇರೋದು 11 ಗುಂಟೆನೂ. ಇದನ್ನ ಹಿಸ್ಸಾ 2 ಅಲ್ವಾ ಇದು?
ಅದು ಕಾಲಮ್ ಸಮಯ
2 ಹಿಸ್ಸಾ ಅಂತ ಇದೆಯಲ್ರಿ ಅದು?
ಹಿಸ್ಸಾ ಅದರಲ್ಲಿ
ಅದೇ ಮತ್ತೆ ಕಾಲಮ್ ಬರೋದು ಅದು.
ಕಾಲಮ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಹಿಸ್ಸಾ ನಂಬರ್ ಅಲ್ಲ. ಹಿಸ್ಸಾ ಇಲ್ಲಿ ನೋಡಿ ಸರ್. ಕಾಲಮ್ ನಂಬರ್ 39 ಇದು ಪೇಜ್ ನಂಬರ್ 39
ಆಯ್ತು.
ಹಿಸ್ಸಾ ಅನ್ನೋದು ಮುಂದಿನ ಅನ್ನೋದ್ರ 2 ಹಿಸ್ಸಾ ಅಂತ ಅಲ್ಲಿ
ಅದ್ರಲ್ಲೂ ಹಿಸ್ಸಾನೇ ಇರೋದು, ಇದ್ರಲ್ಲೂ ಹಿಸ್ಸಾನೇ ಇರೋದು. ಆಯ್ತು ಆಯ್ತು ಬಿಡಿ ಅಷ್ಟೇನಾ?
ಇದರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅವರು ನನ್ಗೆ ಹಣ ವಾಪಸ್ ಕೊಡಿ ಇಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಬರ್ಕೊಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾವು ಕೇಳಿದ್ವಿ. ಕೊಡದೇ ಇರೋದ್ರಿಂದ ಈ ಕಂಪ್ಲೇಂಟ್ ಅನ್ನ ಫೈಲ್ ಮಾಡಿದ್ವಿ. ಆಲ್ಟರ್ನೇಟಿವ್ ರೆಮಿಡಿ ಇಸ್ ಅವೈಲಬಲ್. Yes, the complaint can file a suit for recovery or suit for special performance.
ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಕೇಸ್ ಹಾಕಿ ಕೊಡ್ತಾರ ಅವ್ರು. ನೀವು ವೇರಿ ಪ್ರಾಪರ್ಟಿ ಮಾರಾಟ ಮಾಡ್ಬಿಟ್ಟು ಮತ್ತೆ ಇನ್ನೊಂದ್ಸರಿ ಅದೇ ಪ್ರಾಪರ್ಟಿನ ಮಾರಾಟ ಮಾಡಿ ವೈ ದೇ ಹ್ಯಾವ್ ಟು ಫೈಲ್ ಸಪರೇಟ್ ಪಿಟಿಷನ್. ಯು ರೀಫಂಡ್ ದಿ ಅಮೌಂಟ್, ದೆನ್ ಐ ವಿಲ್ ಪಾಸ್ ಅನ್ ಆರ್ಡರ್. ಯು ರೀಫಂಡ್ ಇಟ್. ಎಷ್ಟು ತಗೊಂಡಿದ್ದೀರಿ? 3,10,000. ಯಾವ ವರ್ಷದಲ್ಲಿ? 2011. ಈಗ 2022 ಇದ್ದೀವಿ. 3,10,000ಕ್ಕೆ. ಆಮೇಲೆ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದು 2011
ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಿ ಬಂದ್ಬಿಟ್ಟು
2013 ಇಂದ ಇದುವರೆಗೂ ನೀವು ಕೋರ್ಟ್ಗೆ ಹೋಗಿಲ್ಲ.
ಅಲ್ಲ, ನಮ್ಗೆ ಸಮಸ್ಯೆ ಬಂದಿಲ್ಲ ಸರ್. ನಾವು ಇವ್ರಿಗೆ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದ್ರ ಬಗ್ಗೆನೇ ಗೊತ್ತಿಲ್ಲ ಸರ್. ಇವ್ರಿಗೆ ಗೊತ್ತಾಗ್ತಾ ಇದ್ದಂಗೆ ಇಮಿಡಿಯೇಟ್ಲಿ ದೇ ಅಪ್ರೋಚ್ ದಿ ಕೋರ್ಟ್.
ಏನ್ರಿ ಅರ್ಲಿಯರ್ ಏನೋ ಇದಾಗಿಲ್ಲನ್ರಿ? ಪ್ರೊಕ್ಲಮೇಶನ್ ಇಶ್ಯೂ ಆಗಕ್ಕಿಂತ ಮುಂಚೆ ಏನ್ ಅಬ್ಸ್ಕಾಂಡೆಡ್ ಕಾಲಮ್ ಅಲ್ಲಿ ತೋರಿಸಿದಾರ ಏನು?
ಹೌದೌದು. ಅದ್ರಲ್ಲಿ ಇನಿಷಿಯಲಿ ದಿ ಕೇಸ್ ಹ್ಯಾಸ್ ಬಿನ್ ರಿಜಿಸ್ಟರ್ಡ್ ಅಗೇನ್ಸ್ಟ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 to 3. ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 is the son, 2 is the father and 3 is the wife. ಅದರಲ್ಲಿ
ನೀವ್ ಯಾರು ಈಗ?
ನಾನು ಅಕ್ಯೂಸ್ ನಂಬರ್ 1.
ನೀವೇ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1. ನಿಮ್ಮ ಬಾಕಿಯವರೆಲ್ಲ ಏನಾಯ್ತು ಅವ್ರಿಗೆ?
ಮತ್ತೆ ಹೆಂಡತಿ ಅಗೇನ್ಸ್ಟ್ ಕೈ ಬಿಟ್ಟಿದ್ದಾರೆ. ಅವ್ರು ಹೇಳೋ ಪ್ರಕಾರ ದಿ ಸೇಲ್ ಡೀಡ್ ಹ್ಯಾಸ್ ಬಿನ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ಬೈ ಫಾದರ್, ವೈಫ್ ಅಂಡ್ petitioner.
All the three.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇಬ್ಬರನ್ನ ಕೈ ಬಿಟ್ಟು ನಮಗೆ ಶ್ರೀಸ್ನರ್ ಅಗೇನ್ಸ್ಟ್ ಮಾತ್ರ ಚಾರ್ಜ್ ಶೀಟ್. ಇದರಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 67 2/3/2008 ಅಲ್ಲಿ
ನಂಬರ್ ಎಲ್ಲ ಇದೆಯಲ್ರಿ?
ಪೇಜ್ ನಂಬರ್ 67
ಹೇಳಿ.
2/3/2008 ಅಲ್ಲಿ issue SS to accused and 2 respondents by 8/8/2018. ಆಮೇಲೆ 8/5/2018 ನಲ್ಲಿ ಅದು ಸಮನ್ ಸರ್ವಾಗಿರೋ ಬಗ್ಗೆ ಯಾವ್ದು ಶರ ಇಲ್ಲ, ರೀಇಶ್ಯೂ NBW ಅಂತ ಆಗಿದೆ.
ಬೇರೆಲ್ಲ ಅಪೇರ್ ಆಗಿಲ್ಲ. ಇಲ್ಲ, ಈಗ ಒಬ್ಬನೇ ಮಾಡಿರೋದು ಅಕ್ಯೂಸ್. ರೀಇಶ್ಯೂ ಸಮನ್ಸ್ ಟು ಅಕ್ಯೂಸ್. ಅರ್ಲಿಯರ್ ಏನು ಇದೆ ಅಬ್ಸ್ಕಾಂಡೆಡ್ ಕಾಲಮ್ ಏನ್ರಿ? ಮತ್ತೇನು ಸರ್ವಿಸ್ ಎಲ್ಲ ಆಗಿದೆ? ರೀಇಶ್ಯೂ NBW, ಇಶ್ಯೂ SS to accuse, ರೀಇಶ್ಯೂ. ಆಮೇಲೆ NBW ಆಯ್ತಾ? NBW to accused. NBW to accused. NBW to accused. Huh? Someone survey ಆಗಿಲ್ವಲ್ಲ?
ಇಲ್ಲಿ page number 14 my lord. Charge sheet.
14 of charge sheet.
Column number 16 ನಲ್ಲಿ ಅಪರಾಧಿ ಈಗ ಎಲ್ಲಿದ್ದಾನೆ? ಸ್ಟೇಟಸ್ ಆಫ್ ದ ಅಕ್ಯೂಸ್. ಕೋರ್ಟ್ ನಿಂದ ಜಾಮೀನು ಅಂತ.
ಇದು ಆಗಂತ ಇದೆಯಾ?
ಅದರಲ್ಲಿ ಅವರು ಟೈಪೋಗ್ರಾಫಿಕಲ್
ಎಲ್ಲಿದೆ ಆಗಂತ?
ಪೇಜ್ ನಂಬರ್ 14.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ
ನೀವು ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ತಗೊಂಡಂಗಿದ್ದೀರಿ ನೋಡಿ ಅದ. ಮತ್ತೆ
ನಮ್ಗೆ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದ್ ಬಗ್ಗೆನೇ ಗೊತ್ತಿಲ್ಲ ಸರ್. ಗೊತ್ತಾಗ್ತಾ ಇದ್ದಂಗೆ ಇಮಿಡಿಯೇಟ್ಲಿ ವ್ಯಾವ್ ಅಪ್ರೋಚ್.
ಎಲ್ಲಿದೆ ಬೇಲ್ ಅಂತಂದ್ರೆ ಕ್ರೈಮ್.
ಕೋರ್ಟ್ ನಿಂದ ಜಾಮೀನು ಅಂತ ಇದೆ. Anticipatory bail.
ಪೇಜ್ ನಂಬರ್ ಅದರಲ್ಲಿ?
ಪೇಜ್ ನಂಬರ್ 14.
ಬಾಟಮ್ ಅಲ್ಲಿ
ಲಾಸ್ಟ್
ಈಗ ಹೊಸದ ಹಾಕಿದ್ರಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಹೊಸದಾಗಿ ಚಾರ್ಜ್ ಶೀಟ್
13, 14.
ಲಾಸ್ಟ್ ಕಾಲಮ್ 16.
ಅಪರಾಧಿ ಈಗ ಎಲ್ಲಿದ್ದಾನೆ? ಇಲ್ಲ ರೀ, ಕೆಳಗಡೆ ಇದೆ ನ್ಯಾಯಾಂಗ ಬಂಧನ ತಲೆಮರೆಸಿಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಕೆಳಗಡೆ ನೋಡಿ.
ಸ್ಟೇಟಸ್ ಆಫ್ ದ ಅಕ್ಯೂಸ್ ಕೋರ್ಟ್ ನಿಂದ ಜಾಮೀನು ಅಂತ ಮೇಲೆ ಅದೇ ಸ್ಟೇಟ್.
ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿದ್ದೆ ಪೊಲೀಸರಿಂದ ಜಾಮೀನು, ಪೊಲೀಸ್ ಕಸ್ಟಡಿ, ಕೋರ್ಟ್ ನಿಂದ ಜಾಮೀನು, ನ್ಯಾಯಾಂಗ ಬಂಧನ ಅಲ್ಲಿ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಅದ್ರಲ್ಲಿ ನೋಡಿ ತಲೆಮರೆಸಿಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಬರ್ತಾರೆ.
ತಲೆಮರೆಸಿಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಥಿಂಕ್ ಮಾಡ್ಬೇಕಾಯ್ತು ಅವರು.
ಸ್ಟೇಟಸ್ ಆಫ್ ದ ಅಕ್ಯೂಸ್ ಕೋರ್ಟ್ ನಿಂದ ಜಾಮೀನು
ಇಲ್ವಲ್ಲ. ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ 3 ಜನ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಟಿದಾರ. ಪಿಟಿಷನರ್ ಮಾತ್ರ. ಅದಕ್ಕೆ ಬೇರೆಯವ್ರ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ. ನೀವೇನು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ದೆ ಬಿಡೋದಕ್ಕೆ ಅದಕ್ಕೆ ಕಾರಣ ಅಂತ ಹೇಳ್ತೀರಲ್ಲ ಮತ್ತೆ.
ಬ್ಯಾಕ್ ಸೈಡ್ ನಾಟ್ ಎ ಗ್ರೌಂಡ್.
ಪ್ರೊಕ್ಲಮೇಶನ್ ಇಶ್ಯೂ ಆಗಿದೆ. ದಿ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಅಂಡ್ ಆಲ್ಸೋ ದಿ ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ದಿ ಸ್ಟೇಟ್. The factual matters of the case of the prosecution is that this petitioner executed sale agreement in favor of the complainant in respect of the property bearing survey number 158/2 for 11 Gunta on 17/2/2011 after receiving an amount of ₹3,10,000. 3 lakh as advance, and the same is also registered sale agreement, and documents are not supplied till 27/5/2013, and also not registered the property, and when suspected and made enquiry comes to know that on 15/3/2010 itself the property was sold in favor of one Murthy, and very same property was registered in favor of the complainant, knowing fully well that property was already sold, and hence complaint is registered. The counsel appearing to the petitioner would vehemently contend that the petitioner is not aware of registration of the case, and while filing the charge sheet also shown the name as absconded, and no summons was served against him, and NBW was issued, and now proclamation also issued against the petitioner, and hence he may be enlarged on bail. For counter, the counsel appearing to the state would submit that very specific allegation is made in the complaint that even though the property was sold in 2010 itself, very same property was sold in favor of the complainant by receiving an advance amount of ₹3 lakh on 17/2/2011, and hence there is a fraud on the complainant at the inception, and hence petitioner is not entitled for bail. The counsel also submits that though the case was registered based on the private complaint filed in 2013 itself, this petitioner did not appear before the court. And now after almost a decade has approached this court by filing the present petition, that too invoking section 438 of CRPC. And already proclamation was issued against the petitioner and hence is not entitled for claim. Having heard the respective counsel and also on perusal of material, particularly specific allegations are made that in spite of the property was sold in the year 2010 itself, the very same property was sold in favor of the complainant, that too by executing a registered sale agreement in favor of the complainant. And also amount of rupees 3 lakhs was received in 2011 itself as advance money. And sale consideration was fixed as per the transaction only 3,10,000. And almost entire amount was paid. That is 3 lakhs. And when such specific allegations are made, when the property was already sold, again the petitioner executed the sale agreement and got received the almost the entire sale consideration. When suspending the case at the very inception, with an intention to cheat the complainant, a registered document was executed in favor of complainant. The counsel also vehemently contend that other two persons charge sheet was not filed, but specific allegation against this petitioner that this petitioner only executed the sale agreement. And hence, the IO did not find any material against other two petitioners and hence not filed the charge sheet against the other two petitioners. The counsel also submits that the other alternative remedies available to the complainant, and the very such submission cannot be accepted when the allegation of fraud at the inception is alleged, and also taking into note of very same property was already sold. And again, the petitioner has received the amount of rupees 3 lakh, almost entire sale consideration out of rupees 3,10,000. And at the inception, with an intention to commit the fraud on the complainant, again entered into a sale agreement. When such material are found, it is not efficacious to exercise the powers of 438 of CRPC to enlarge the petitioner on bail. The other contention of the petitioner counsel that no summons was issued and a warrant has been issued and proclamation is also issued, and the fact that the complaint was filed in 2013 and the proclamation was issued almost after a decade. And having considered the merits of the petition, no case is made out to the petitioner to enlarge him on bail, and the very presence of the petitioner is required. And hence, not a case for granting anticipatory bail. Pass over, right? ಎರಡನೇದು ಪಾಸ್ ಅವರ 41 ಪಾಸ್ ಅವರ ಆಯ್ತು. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಲ್ಲ ಮೆಟೀರಿಯಲ್?
Initially, my lord, FIR was registered for 302. Charge sheet registered for 306.
306.
306. 439 petition. Two accused were charge sheeted. A2 is a mother-in-law. A1 is a husband.
Now, petitioner is only the husband or husband? What about mother-in-law?
Considered by a lordship. She is on enlarged on bail. Petitioner is accused number 1, husband. The charge sheet.
Yes.
Column number 70. Case of There was a allegation, as per the charge sheet allegation, accused number 1 and disease was left with a female girl. Accused number 2 was instigated that arguably last time. But on that, Lord, she was got frustrated. And there was a quarrel in place. And she got committed suicide. But as per the charge sheet allegation, this is not the allegation. The real allegation, real fact, my lord, she was insisting the petitioner to give fees for her daughter, my lord. 40,000 ದುಡ್ಡು ಅರೇಂಜ್ ಮಾಡಿ ಇದು ಮಾಂಟೆಸರಿಗೆ ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು. This petitioner was doing water business. Akshaya water business, can ತುಂಬಿಸಿ ಅಂಗಡಿಗಳಿಗೆ ಕೊಡೋದು. So there was a dispute. He was say that their business ದಲ್ಲಿ ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು ಅಂತ. She didn't listen. ಅದಕ್ಕೆ ಕೋಪದಿಂದ ಹೋಗಿ ರೂಮ್ ಹೋಗಿ ಜೋರಾಗಿ ಬಾಗಿಲು ಹಾಕೊಂಡು ಮಲ್ಕೊಂಡೆ. Thereafter morning, this petitioner and daughter saw that she was in hanging position in the ceiling fan. But now the charge sheet says that ಗಂಡು ಮಗು ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳೋದು. This is a related allegation. That is not the allegation, real allegation. It is a love marriage case. They were residing separately, husband and wife. $50,000 ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ
ಏನ್ರಿ
custody from 24 up to 22.
Yes, and as per the complaint, it's a frequent
frequent quarrel, and she has not given birth to a male child. Instead of she gave birth to a
times abortion.
There is no material for that. It's a statement.
No. Heard the petitioner, counsel, and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the deceased or victim, the victim married this petitioner, and in the said wedlock she gave birth to a girl child, which is aged about 2 years. The mother-in-law was not happy with the marriage of victim with the accused number 1, and she was instigating this petitioner, and at the instance of the mother-in-law, this petitioner was subjecting her for both mental and physical harassment. Due to the said harassment, she consumed the phenyl, and this petitioner also frequently, at the instance of his mother, subjecting her for both mental and physical harassment. The same is witnessed by CW 1, 7, and 8, and they have given the statement. And when she gave birth to a girl baby, harassment continued and abated her to commit the suicide, and hence on 19/4/22 she committed suicide by hanging herself. The counsel appearing for the petitioner would submit that a false story is created by the complainant, and she was never subjected to any harassment. And this court already granted bail in favor of accused number 2 in criminal petition number 4486 of 22, with order dated 6th day of June 2022. And the investigation already been completed and charge sheet is also filed. The counsel would submit that This petitioner is in custody from 24-22. And almost 3 months has been completed and no need of further custody. And the allegation of subjecting her for harassment and abetting suicide has to be tested in trial. For contra, the counsel appearing for the state which submits that in the allegations, specific allegations are made that this petitioner at the instance of accused number 2 subjecting her for both mental and physical cruelty. The same is witnessed by CW 1, 7 and 8, and they have also given the statement. And hence there is a prima facie case. Having heard the respective counsel and also on perusal of material, investigation has been completed and charge sheet is also filed, and this petitioner is in custody from 24-2022. On perusal of material, though at the first instance 302 is invoked, and during the course of investigation it is emerged that cause of death is due to hanging, and hence invoked the offence under section 306 of IPC. The allegation is also that both of them subjected her for both mental and physical harassment and abetted in committing the suicide. Whether it attracts section 306 or not has to be tested in trial during the course of the trial. And no need of further custody. Hence, it is a fit case to exercise the power under section 439 of CRPC. The court also has to consider the material whether there is a proximity to cause of death and taking extreme steps of committing suicide. And the same only can be done during the course of the trial. Hence, petitioner is enlarged on bail with conditions.
CC number, my lord. CC number 31828.
In CC number
31828.
828 of 2022. Adana order portion al haki madam.
My lords, I'm for the petitioner, my lords, in serial number 43, my lords.
Yes, counsel.
My lords, I'm a proxy counsel, my lords. My colleague, who is the counsel on record, is not keeping well, my lords. A short accommodation may be given, my lords.
What happened to him?
My lords, he is down with fever, my lords, because of the weather, my lords.
Then,
my lords, a week's time may be given, my lords.
Yeah,
Also,
ಇದು 439 petition.
Stay ಆಗಿದೆಯಾ? ಏನ್ರಿ ಸ್ಟೇ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ?
My lords, I beg your pardon, my lords, I have no instructions on that, my lords.
And then why, without instruction, why you are making submission before the court?
My lords, on behalf of my colleague, my lords, he was not keeping well. A week's time may be given, my lords. We shall address our arguments.
This matter on 21st.
Very much obliged, my lords.
ಅದೇನಾಯ್ತು ಮೇಡಮ್, ಇನ್ನೊಂದು ಸತೀಶ್ ಚಂದ್ರ ಅರ್ಜುನ್ ಆಯ್ತು 45 ಸಾಮ್ಯುಯಲ್ ಎಸ್ ದಂಡಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕ್ಯಾನ್ಸಲೇಷನ್
Petitioner is the complainant.
ಅಲ್ರಿ, ಅವ್ರಿಗೆ ಅಪರ್ಚುನಿಟಿ ಕೊಡೋದು ಬೇಡವಾ? ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲ್ ಕೊಡ್ಬೇಕಲ್ಲ. ನೀವು 50 ಹಾಕಿದ್ದೀರಾ. ವಾಟ್ ಇಸ್ ಯುವರ್ ಗುಡ್ ನೇಮ್? ವಾಟ್ಸ್ ಯುವರ್ ಗುಡ್ ನೇಮ್? ಜಗದೀಶ್ H.T. Counsel Sri Jagdish H.T. submits that today he has filed wakalat on behalf of R2. Hence, office is directed to put up the wakalat and show the name of the counsel. And counsel seeks time to file objections. Right? This matter. Next week, another on date. 25th. S.C. Raghavendra Reddy. Some genuineness, but some genuineness in order date of birth. Yes, notified the complainant and seeks time to verify with regard to the genuineness of document of date of birth which shows the date of birth of the victim as 7/1/2004 ಅಂತಿದೆ. ವೆರಿಫೈ ಮಾಡಿದ್ರೇನ್ರಿ? ಹೇಳಿ ಏನು?
2004 is victim. 22/4/2004.
Our date of birth. As per school
As per the
records.
school records.
ಮತ್ತೆ ಇವ್ರು ಕೊಟ್ಟಿರೋದಾದ 7/1/2004 ಅಂತಾನೆ ಹೇಳಿ.
ಅದ್ರಲ್ಲಿ victim ಅವ್ರು ಹೇಳ್ತಾರೆ. Victim. The submission is.
Victim
And the accused date of birth is 7/1/2004.
7/1/2004 is accused.
Accused. Date of birth.
ಈಗ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿರೋದು ಯಾರ್ದು ಇದು ವೆರಿಫೈ ಮಾಡಕ್ಕೆ ಅಕ್ಯೂಸ್ಡ್ ಏನ ವೈ ಇಸ್ ದರ್ ಎನಿ ಆಕೆ 7/1/2004 ಅಲ್ಲ ಆಕೆದು 22/4/2004 ವಾಟ್ ಇಸ್ ದಿ ಕೇಸ್ ಎಫ್ಐಆರ್
17 ವರ್ಷ
ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಅದೇ ಇದು ಕೃತ್ಯ ನಡೆದ ದಿನಾಂಕ ಮೇಲೆ
ಎಫ್ಐಆರ್ ಏನ್ ಮಾಡ್ರಿ ಎಫ್ಐಆರ್ ಹಾಕಿದಾರ ಹೇಳಿಕೆ ಎಫ್ಐಆರ್ ಹೇಳಿ ಏನ್ ಓದಕ್ ಕಾಣದೇ ಇಲ್ವಲ್ರಿ ಈ ತರದ ಎಫ್ಐಆರ್ ಆಗ್ತಿದೆ ಏನ್ ಓದೋದು ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲ ಇದೆ ಕೃತ್ಯ ನಡೆದ ದಿನಾಂಕ ಥರ್ಸ್ಡೇ ಅಂತಾನೆ ಇದೆ
As per the document, 13/5 is minor.
13/5
Accused minor.
Accused was minor.
13/5. But continuous is 13/3/22 ವರ್ಗು ಇದೆ. But now 13/3 ವರ್ಗು ತಗೊಂಡ್ರೆ major. But initially 13/5 ನಲ್ಲಿ minor. As per the birth certificate ದಿನೇನ್ ಇದೆ. Date of birth ಇದೆ.
But it goes back to the date of crime ಅಲ್ವಾ ಫಸ್ಟ್ ಏನಾಗುತ್ತೆ ಅದೇ ಅದೇನೆ ಬರ್ತದೆ ಮೇ ಬಿ ಕಂಟಿನ್ಯೂಸ್ ಆಕ್ಟ್ ಏನಲ್ಲಿ ವಾಟ್ ಇಸ್ ದಿ ರಿಸಲ್ಟ್ ನಾವು
ಅವರು ಪ್ರೆಗ್ನೆಂಟ್ ಆಗಿದ್ದಾರೆ.
ನಾವು ಸಿ ಬಿಕಮ್ ಪ್ರೆಗ್ನೆಂಟ್ ಆಲ್ಸೋ ಮಗುನೂ ಆಗಿದೆ ವೇರ್ ಇಸ್ ಶಿ ನೌ ಆಕೆ ಮಗು ಎಲ್ಲ ಎಲ್ಲಿದೆ ಮನೆಯಲ್ಲಿ ಆಯ್ತು ಈಗೇನು ಮದುವೆ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಇಲ್ವಾ ಮೈನರ್ ಈಗ ಮೇಜರ್ ಆದವ್ರಲ್ಲ ಆಕೆ ಎಷ್ಟು ಇನ್ನು ಏಜ್ ಇವನು ಮೇಜರ್ ಆಗಿದ್ದಾನಲ್ಲ
ಅವರಲ್ಲಿ ಮದುವೆ ಆಗಿದ್ದ ನಾನು ಭರತೆ ಮುಡುಗು ಇಷ್ಟಪಟ್ಟಿದ್ದೆ ನಾವು ನ್ಯಾಮತಿಂದ್ರ ಕೃಷ್ಣ ದೇವಸ್ಥಾನ ಕಡೆ ಬಹಳಷ್ಟು ಸೇರಿದೀವಿ ಆಗ ನಾನು ಪ್ರೆಗ್ನೆಂಟ್ ಆದ ವಿಷಯ ನನಗೂ ಅವನಿಗೆ ಗೊತ್ತಿತ್ತು ನಾನು ಅವನು ಯಾರಿಗೂ ಹೇಳಿರ್ಲಿಲ್ಲ ಇಬ್ಬರು ಹಂಗೆ ಮುಚ್ಚಿಟ್ಟುಕೊಂಡಿದ್ವಿ ಅದು ಅವರದೇ ಪಾಪು ಅವನನ್ನು ಬಿಟ್ಟುಕೊಟ್ಟರೆ ನಾವು ಮದುವೆ ಆಗುತ್ತೇವೆ ನಮ್ಮ ಕಡೆಯವರು ಅವರ ಕಡೆಯವರು ಒಪ್ಪಿಕೊಂಡಿರ್ತಾರೆ ನಮ್ಮ ಮನೆಯವರು ಇದ್ದಾಗ
ಹೇಳಿದಾಳ ಹಾಗಂತ ಅಡ್ವೈಸ್ ಯುವರ್ ಕ್ಲೈಂಟ್ ಮತ್ತಲ್ಲ ಹೊರಗಡೆ ಬಂದ್ಮೇಲೆ ಇನ್ನು ಮಾಡೋದವನು What the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the complainant father in the hospital made the statement that ಯಾರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡ್ರಿ ಆಕೆನೇ ಇರ್ಬೇಕು the victim has given the complaint, victim has given the statement when they gave birth to a child that she was pursuing her education in University College. And she came in contact with this petitioner, and both of them started loving each other. And subjected her for sexual act, and the same was continued. As a result, she became pregnant, and now she gave birth to a child. Based on the complaint, police have registered the case. Invoking an offence punishment from 363, 376 to N and POCSO Act, 6 of POCSO Act. The counsel appearing for the petitioner would submit that the petitioner is also a minor, considering the date of the alleged crime, that is 13/5/2021. And the date of birth of the petitioner is 7/1/2004. And at the time of the alleged crime, he was 17 years, 4 months and 6 days. The trial court ought to have considered the provisions of Juvenile Justice Act and enlarged the petitioner on bail. And complaint is lodged on 4/3/2022 after lapse of 10 months. And the petitioner is innocent and he has not committed any such offence. And he is ready to obey the conditions. For contrary, the counsel appearing to the state would submit that the allegation against the petitioner is that subjected her for continuous sexual act. Although he was a minor on 13/5/21, and last act was 13/3/2022, and by that time he was major, and also subjected the victim girl for sexual act continuously, and it attracts section 6 of the POCSO Act, and it is an heinous offence. The counsel also brought to notice of this court the 164 statement of victim girl, wherein she has stated that both of them were loving each other. And both had sexual act. As a result, she became pregnant and now she gave birth to a child. If the petitioner is enlarged on bail, they are going to live together. And both of them will marry. And there is a consent from both the family. Having heard the respective counsel and also on perusal of material available on record, particularly the allegation made in the complaint, that is in the statement of victim girl, and also the statement made by the victim before the court on 21/3/2022, and also the fact that this petitioner was minor at the time of the alleged incident of committing the crime. And also in keeping the punishment provided to a juvenile under the act, and apart from that 164 statement of the victim girl made before the learned magistrate on 21/3/2022, and both of them intend to marry and to live the life as husband and wife. And also the family members are given consent. And considering the peculiar circumstances of the case, in view of the statement of victim girl as well as the there is a juvenile at the time of committing the crime, it is a quick case to exercise the powers of the court of the line of CRPs. In view of the discussions made up, I pass the following order. Bail petition is allowed with conditions.
Thank you, place on 27/2021. Complaint has lodged for the police on 27/3/2021. About one delay in 1 month. Petitioner in initial custody from 4/2/2022.
The complainant and present petitioner very well, both are close relatives, my lord. Moreover, known to each other from past several years. Moreover, my lord, as per the now the charge sheet has been filed, my lord. A statement made by the Manjunath, who is the husband of the complainant, at page number 21. Before the incident, my lord, she sent photos and voice message conversation to the present accused. Sent a conversation and photos are much earlier the incident, my lord. She sent to the present petitioner. In this regard, my lord, the police has not seized any material documents, my lord. The phone has not been seized by the police, my lord. Moreover, on page number 27, my lord, a statement of one Vijay Kumar, my lord, brother-in-law of the present complainant. He states that, my lord, on one PW3, one Shiv Kumar has sent a message with photos and voice message to the Vijay Kumar, my lord. The Vijay Kumar phone also not been seized by the police, my lord. Page number 21, my lord.
21.
21, my lord, is the statement made by one Manjunath. Para 3, my. ಸದರಿ ವಾಯ್ಸ್ ರೆಕಾರ್ಡ್ಗಳನ್ನು ನಾನು ಕೇಳಿಸಿಕೊಂಡು ಅದರಲ್ಲಿ ಕೃಷ್ಣಪ್ಪ ಮತ್ತು ನನ್ನ ಹೆಂಡತಿ ಸೋನ್ಸೋ ಅವರು ಮಾತನಾಡಿದ್ದು, ಶೋಭಾ ನಾನು ಸೋನ್ಸೋ ಫೋಟೋವನ್ನು ಕೃಷ್ಣಪ್ಪನಿಗೆ ಕಳಿಸಿದ್ದು, ಅದನ್ನು ಡಿಲೀಟ್ ಮಾಡಿದೆ ಎಂದು ಕೃಷ್ಣಪ್ಪನಿಗೆ ಕೇಳುತ್ತಾಳೆ. ಅದಕ್ಕೆ ಕೃಷ್ಣಪ್ಪ ನಾನು ಸೋನ್ಸೋ ಅಂತ ಫೋನಲ್ಲಿ ಮಾತಾಡಿದ್ದು, ಶೋಭಾ ಅವರಿಗೆ ಮಾತಾಡಿರೋ ವಾಯ್ಸ್ ರೆಕಾರ್ಡ್ ಇತ್ತು. The phone has not been seized, my lord, whether when it was sent to the phone and then other messages were sent to the present petitioner, my lord. So far as, my lord, one page number 27, my lord, statement of Ch-17, my lord, brother-in-law of the present petitioner. That also, my lord, para number 2, my lord. ನಾನು ಮತ್ತು ನನ್ನ ತಮ್ಮ ಮಂಜುನಾಥರು ಈಗ ಸುಮಾರು 20 ವರ್ಷಗಳಿಂದ ಸೋನ್ಸೋ ಗ್ರಾಮದಲ್ಲಿ ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದೆ. ಹೀಗೆ 3-4 ತಿಂಗಳ ಹಿಂದೆ ನನಗೆ ಮತ್ತು ಪರಿಚಯ ಶಿವ ಎನ್ನುವರು ನನ್ನ ಚಿಕ್ಕಪ್ಪ ವೆಂಕಟಣ್ಣಪ್ಪನವರ ಮಗನಾದ ಕೃಷ್ಣಪ್ಪ ಪ್ರೆಸೆಂಟ್ ಪಿಟಿಷನರ್ ಅವರ ಮೊಬೈಲ್ ಫೋನ್ ಅನ್ನು ಕೊಂಡುಕೊಂಡಿದ್ದ. ಸದರಿ ಮೊಬೈಲ್ ಫೋನ್ ನಲ್ಲಿ ನನ್ನ ತಮ್ಮನ ಹೆಂಡತಿ ಸೋನ್ಸೋ ಮತ್ತು ಕೃಷ್ಣಪ್ಪರವರು ಮಾತಾಡಿದ್ದ ವಾಯ್ಸ್ ರೆಕಾರ್ಡ್ ಕೇಳಿಸಿಕೊಂಡು ನನಗೆ ಹೇಳಿದ್ದನು. Contradictory statement, my lord. One Vijay Kumar stating that, my lord, one Shiv Kumar has told to me regarding the voice message and then photos, my lord. As per the Manjunath statement, my lord, page number Shiv Kumar statement, page number 31, my lord. Para 3, ಸದರಿ ಶೋಭಾ ಎಂಬುವರು ನನಗೆ ಪರಿಚಯವಿದ್ದ ವಿಜಯ್ ಕುಮಾರ್ ಅವರ ತಮ್ಮ ಮಂಜುನಾಥನ ಹೆಂಡತಿಯಾಗಿ ಆಕೆ ಕೃಷ್ಣಪ್ಪನ ಕಾಲ್ ರೆಕಾರ್ಡ್ಗಳನ್ನು ಇಟ್ಟುಕೊಂಡು ಬೆದರಿಕೆ ಹಾಕಿರುವ ವಿಷಯವನ್ನು ತಿಳಿದು ಬಂದಿದ್ದ. ಸದರಿ ವಿಷಯವನ್ನು ಕಾಲ್ ರೆಕಾರ್ಡ್ಗಳು ವಿಜಯ್ ಕುಮಾರ್ ಅವರಿಗೆ ಕೇಳಿಸಿದ್ದು, ಅವರು ಕೇಳಿಸಿಕೊಂಡ ನಂತರ ಅವುಗಳನ್ನು ಅವರ ಮೊಬೈಲ್ಗೆ ಕಳಿಸಿಕೊಂಡರು. The prosecution has not seized the phone of the Vijay Kumar and then Shiv Kumar phone also not been seized. Delay in 1 month in filing a complaint. Initial custody since from 4 to 2022, my lord. Only returning member in the family, my lord. Moreover, she is a major. Keep quiet. Silence in here. 27 to 2021 to 27/3/2021, my lord. The current of the complainant got into knowledge of these messages and photos, my lord. She immediately lodged a present complaint, my lord, at the time itself, my lord.
Lord, complaint is very specific, my lord. Page number 12. Page number 13, my lord. ನಾನು ಒಪ್ಪದಿದ್ದರೆ ನನ್ನ ಜೊತೆ ಮಾತನಾಡಿ ವಾಯ್ಸ್ ರೆಕಾರ್ಡ್ ಎಲ್ಲರಿಗೂ ಮರ್ಯಾದೆ ನಾನು ಆತನ ಜೊತೆ ಒಪ್ಪಿದ್ದಾಗ ದಿನಾಂಕ 1/3/2020 ನಮ್ಮ ಜೊತೆ ಮಾತನಾಡಿದ ವಾಯ್ಸ್ ರೆಕಾರ್ಡ್ಗಳು ನಮ್ಮ ಭಾವಕ್ಕೆ ವಿಜಯ್ ಕುಮಾರ್ ಅವರಿಗೆ ಯಾರೋ
ಸಮಭಾವನೆ ಈ ಬಗ್ಗೆ ನನ್ನ ಗಂಡ ಮಂಜುನಾಥ್ ಅವರು ಹೇಳಿದ್ದಾರೆ. ನಂತರ ನನ್ನ ಗಂಡ ನನ್ನನ್ನು ಕೇಳಿದಾಗ ನಡೆದ ವಿಷಯವನ್ನು ನಾನು ನನ್ನ ಗಂಡನಿಗೆ ಹೇಳಿರುತ್ತೇನೆ. ದಿನಾಂಕ 24/3/21 ಸುಮಾರು 5 ಗಂಟೆಯಲ್ಲಿ ನಾನು ಮತ್ತು ನನ್ನ ಗಂಡ ತಮ್ಮ ಕೆಲಸ ಮಾಡುವ ದೊಡ್ಡ ಬನಹಳ್ಳಿ ಗ್ರಾಮ ವಿದ್ಯಾಭ್ಯಾಸ ಆತ ನನ್ನ ಗಂಡನಿಗೆ ಕೈಗಳಿಂದ ಹೊಡೆದು ಬೈದು assaulted also. And PW2 husband also stated that he had assaulted him on 24/3/21. And he says that ನನ್ನ ಅಣ್ಣನ ಮೊಬೈಲ್ ಫೋನ್ ನಲ್ಲಿದ್ದ ವಾಯ್ಸ್ ರೆಕಾರ್ಡ್ಗಳನ್ನು ಅದನ್ನು ಡಿಲೀಟ್ ಮಾಡಿರುತ್ತಾನೆ. ದೇರ್ ಇಸ್ ನಾಟ್ ಬಿ ಡ್ರೈವ್ಡ್. ಅದರ ಮೊಬೈಲ್ ಸಹ ಬೈಕ್ ನಲ್ಲಿ ಹೋಗುವ ಹೊಡೆದಿದ್ದರಿಂದ ಅದನ್ನು ಬಿಸಾಡಿರುತ್ತಾನೆ. The mobile could not be traced. Page number 22. And 164 also he was categorically stated that the incident.
So, or the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that CW1 is the relative of this petitioner. And this petitioner came when the complainant was in the house and informed that he came to see CW2. And when the CW1 went inside the house, he came inside the house and closed the door and subjected her for sexual act against her wish, and also threatened not to disclose the same and also threatened that she is going to commit the murder of her husband. When the said fact came to the knowledge of husband of CW1, both of them went to the house of the petitioner on 24/3/21, and he assaulted with the hands and also abused in a filthy language, and also caused the life threat. And hence, case is registered against the petitioner herein. Petitioner counsel would vehemently contend that the alleged incident was taken place on 27/2/21. And complaint was given on 27/3/21. Almost there is a delay of 1 month in lodging the complaint. The counsel also would submit that this petitioner is in custody from 4/2/22. The counsel would submit that in the statements of witnesses, an allegation is made that the same has been recorded and sent to the mobiles. But contrast statements are given by different witnesses and mobile was also not seized. And hence, petitioner is entitled for bail. For counter, the counsel appearing for the state will submit that specific allegation is made that taking the advantage of the complainant alone in the house, he went inside the house and closed the door and committed sexual act against her wish, and also threatened not to reveal the same anybody else, and also threatened the life of her husband. The counsel also would submit that when the said fact comes to the knowledge of CW1 husband, both of them went there and questioned the act of the petitioner and he assaulted with their hands. And apart from that, they start the evidence available in the mobile. Having heard the respective counsel and also on perusal of material, no doubt, according to the prosecution, incident was taken place on 27/2/21. The complaint was also given on 27/3/21 of lapse of 1 month. And also specific allegation is made that when the said fact brought to the notice of her husband, both of them went near the house of this petitioner and subjected for assault. It is also specific allegation that when she did not agree to continuously have the sexual act, that on 1/3/21, the voice record which was recorded was sent to her husband. When she did not agree for sexual and someone has sent the voice message conversated between the petitioner and also the victim. Same was sent to her brother-in-law. And the same was inquired by her husband. And on inquiry, she revealed the same to her husband. Specific date is also given that on 24/3/2021, when they went near the house of this petitioner, he assaulted. Having taken note of specific allegation is made against him that he went and subjected her for sexual act by closing the door forcibly as against her wish. And also specific allegation is made that when they went and questioned the act of the petitioner, he assaulted her. And having taken note of heinous offense of her, subjecting her for sexual act that to a married woman, it is not a fit case to exercise the discretion in favor of the petitioner, since specific allegation is also made that not only caused the threat to her, and also he has threatened the life of the complainant husband, and also sent the conversation message to others. Discussions made up by pass the following order. Bail petition is rejected. Shiva Prasad, yes. Absent, pass over. B2.
Case number 2, the case and counter case with respect to some loan which is supposed to have borrowed from the cooperative society. The allegation is that the accused number 1 borrowed loan from her from the cooperative society of 1 lakh rupees in the name of complainant, and was not paying properly. Therefore, complainant asked her to pay the amount, for which the quarrel happened between the family and the family members of accused number 1, accused number 2, accused number 1 and 2, husband and wife, supposed to have assaulted the complainant and her husband. In the course of the assault, that the accused number 2 supposed to have taken a bricks available there and hit on the face, which resulted in teeth from the husband of complainant has been fallen. My complaint is that my mother-in-law filed a complaint saying that the 30,000 rupees was received by the complainant, which was not paid back since years. And when they learned that she received the loan, she received some salary, they went and asked the amount for which they did not pay. And the husband of the complainant was drunk. He attacked the family, my wife, who is accused number 1, and at the at the time, my son also came, and then they were trying to release the thing. At that time, the husband of the complainant fell down and then broke the leg. That is my complaint. That's also been registered.
Oh, case and counter case.
Case and counter case. Accused number 1, 4, and 5 have been released on enlarged on anticipatory bail. Accused number 3 was released on regular bail, and I am the accused number 2.
What is the allegation against you?
I am supposed to have taken the bricks from the spot and hit the husband of the complainant.
At this spot.
Complainant is the first complaint. Subsequently, they give the counter complaint.
Case and counter case. One is crime number 52, another is 53.
What I say is traditionally it's victim by bricks, my lord.
How long he was in the hospital? ಏನು ಹಲ್ಲೇನ ಬಿದ್ದೋಗಿದೆ ಅಂತ.
ಹೌದು, ಯುಎಸ್ ಇದೆ. ನಂಬರ್ 1. ಎರಡು
ಯಾರು ನೈಬರ್ಸ್?
ನೇಬರ್.
Swelling and left. Injury number 1 is grievous. Swelling left eye, eyelids ಅಲ್ಲಿ. Examination date 13/6. Admission ಯಾವಾಗ? 13/6. Discharge?
Complaint filed the next day.
The date of discharge ಯಾವಾಗ? How long the injured was in the hospital?
We went to Manipal hospital. From there, they came back to Chinmay hospital.
Injured is only one injured. So, what is the petitioner counsel and also the counsel appearing for the state? The factual matters of the case of the prosecution is that the accused number 1 had borrowed a loan of rupees 1 lakh from SK Sangha in her name, but the same has not been repaid in spite of demand by the complainant. That on 13/6/22 at 9 p.m. the accused number 1 along with accused number 2 and her son and their son accused number 3 and daughter accused number 4 trespassed the property of the complainant and picked up a quarrel regarding non-payment of the loan amount. The accused number 1 assaulted the complainant on her cheeks, accused number 3 by holding the hands of the complainant, abused in filthy language, pulled the nightie of the complainant. By hearing the screaming sound, the husband of complainant rushed to the spot and tried to pacify the quarrel. At that time, the accused number 2, that is the petitioner herein, who is the accused husband of accused number 1, assaulted the complainant husband with brick on his face. And all the accused assaulted the complainant and her husband with hands and legs and threatened for their life. The husband of complainant had sustained grievous injuries on his face. Complaint is not. The counsel appearing for the petitioner submits that the petitioners and also the complainant party are the neighbors, And counter case is also filed wherein a specific allegation is made that 30,000 amount was received and the same was not repaid. And hence there was an ill will. The counsel would submit that the injured is out of danger and already other accused persons have been enlarged on bail. And only allegation against this petitioner, he suddenly picked up the brick and assaulted. And in view of case and counter case between the parties, and also the offence is not punishable with death or imprisonment for life, petitioner may be enlarged on bail. For contra, the counsel appearing for the state would submit that the other complaint is filed after court, and the present complaint, present crime is registered as 52 of 22, and subsequent after that complaint is registered as 53 of 2022. And injured also sustained grievous injury. And merely because the injured is out of danger is not a ground to enlarge the petitioner. And the specific court act is made against this petitioner that he assaulted with brick. As a result, he has sustained grievous injury. Having heard the respective counsel and also on perusal of material, and material discloses that they are the neighbors. And also looking into the contents of the complaint as well as counter complaint, there was a financial transactions between them, that is availing the loan by A1 to the tune of rupees 1 lakh in the name of the complainant. And with regard to the non-payment of the amount, a quarrel was taking place. In the counter allegation in the complaint also, that is with regard to the transaction of 30,000 received and not paid the amount. And court has to take note of the circumstances under which an incident was taking place, and both of them are neighbors. And apart from that, the injured is out of danger, and court has to take note of gravity of the offence and accusation made in the complaint. And in the case on hand, there are case and counter cases between both the parties. Under the circumstances, it is a fit case to exercise the powers of the case of CRPC with conditions. Yes.
Petitioner is accused of one. A1 is released on bail. Support that. Section 17. The date of offence on 10/3/21. The 13th March 2021, case came to be registered against unknown person. Subsequently, after lapse of 7 months, accused number 2 were arrested. On his voluntary statement, his name is appeared in the demand application, accused number 2. Up to 7 months, there is no proof against this accused number 2, either is accused number 1.
Any recovery?
Recovery is concerned, regarding the accused number 2, is 5,000 rupees recovery.
Yes. From A2. Any other criminal antecedents? Then similar offense or different offense? Oh. Innೊಂದು crime. How the petitioner, counsel, and also the counsel appearing to the state. The factual matters of the case of the prosecution, based on the complaint, that complainant is having shed in the land belongs to her sister, and they have, and they are grazing 20 sheep. 20 ಇದೆ ಸುಮಾರು 20 ಮೇಕೆಗಳನ್ನು
ಸಾಕಣೆ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ.
20ರಲ್ಲಿ that on 10/3/21, after feeding the sheep, on next day 11/3/21 went near the shed at 6 o'clock and found missing of 9 sheep worth of rupees 1,45,000. And they searched around the area, but they did not find. And complaint was given on 13/3/21. Thereafter, the accused number 2 was apprehended and the recovery of rupees 5,000 was made, and the voluntary statement, on the basis of voluntary statement of A2, this petitioner is also arraigned as accused number 1. The counsel appearing for the petitioner will submit that though alleged theft was taken place on 10/3/21, complaint was given on 13/3/21 after 3 days. And apart from that, after 7 months, based on the voluntary statement of the accused number 2, this petitioner has been implicated, and this petitioner has not committed any offense as alleged in the complaint. For content, the counsel appearing for the state will submit that this petitioner also indulged in committing similar offense. Not similar offense. Theft of TV andralla, committed an offense of theft of TV, and he is an habitual offender. And recovery has to be made at the instance of this petitioner, and hence the very presence of this petitioner is required, and hence cannot be granted with an anticipatory bail. Having heard the respective counsel, and also on perusal of material, the incident was taken place on 10/3/21, and that is also the theft of sheep. And based on the voluntary statement of accused number 2, this petitioner has been implicated in the case. The recovery is also only an amount of rupees 5,000 at the instance of accused number 2. And the recovery only money and not the sheep. And when suspending the case, when this petitioner has been implicated based on the voluntary statement of accused number 2, it is appropriate to enlarge the petitioner with conditions to cooperate with the IO. The other case registered against the petitioner, that is theft of TV, is not a ground to reject the bail petition of this petitioner, and this court can direct the petitioner to cooperate with the IO. In view of the discussions matter by classical order, the petition is allowed with conditions. ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? ಆಗಿದೆಯಾ? ನೋಡ್ರಿ ಜಾರಿ ಆಗಿದೆ ನೋಡಿ. ನೋಟಿಫೈ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀವಿ, ನೀವು ಮಾಡಿದಿರಾ ಇಲ್ಲ? ರೆಕಾರ್ಡ್ಸ್ ಬೇಡ, ನೀವು ಮಾಡಿದಿರಾ ಇಲ್ಲ? ನೋಟಿಫೈ ಮಾಡಿದಿರಾ ಇಲ್ಲ? ರೆಕಾರ್ಡ್ಸ್ ಬಂದಾಗ ಆಯ್ತು. ಎಷ್ಟು ದಿವಸ ಬೇಕು? ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ? ಬಟ್ ಅವ್ರ ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿ ಅಂತಾರಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ ಅಂತ ಕೊಡಿ ಮೇಡಮ್. ಯಾವಾಗ ಬೇಕು? ಯಾವಾಗ ತರಿಸ್ತೀರಿ? ಎಲ್ಲಿ? ಯಾವ ಊರು? ದಾವಣಗೆರೆ. ಮತ್ತೆ ನೀವು ರೆಕಾರ್ಡ್ ತರ್ಸ್ಕೊಳಕ್ ಆಗುತ್ತೆ ನಾಳೆಗೆ? ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ? Day after tomorrow. HCGP since 2 days time to get the records. And as this matter on 20th.
Petitioner has been arrested and in jail since 6 months for the alleged offense under section 302 of Penal Code. The investigation is complete and charge sheet also has been filed in this case. My lord, the deceased died under suspicious circumstances in a unfinished under construction building at Shira town of district Tumkur. The body of the deceased had received severe bruises and a ligature mark was also found on the neck, suggesting that he was attacked or he was beaten black and blue and also throttled to death. Now, next day, the brother of the deceased goes to Shira police station and files a complaint. In his complaint, he alleges that he is suspecting the petitioner in this crime. My lord, may kindly peruse the background of this deceased, because since there is allegation in the complaint alleging that my hand is involved in this crime, the police next day, on the very day itself, arrested me and my voluntary statement was recorded and a charge sheet is filed without producing any substantial material to show that I am involved in this crime. No material has been placed. There are no eyewitnesses to the alleged incident.
CW 3 and 4 eyewitnesses ಅಂತಾನೆ ಹೇಳ್ತಾರಲ್ಲ.
Last three together theory witnesses, Your Honor. He was never found.
Both were together ಅಂತ.
There is no material.
Case is rest upon the circumstantial evidence.
Please, I will come to that aspect. At least, my lord, a statement of some witnesses shall be recorded by the investigating officer that the petitioner was found in that unconstructed building along with the deceased. There is no such material, Your Honor. He was found earlier in previous day along with petitioner and deceased were friends, Your Honor. In fact, the petitioner has helped deceased on so many occasions. On the previous day he was found, and the spot wherein the dead body was found is an open space, Your Honor. It was unfinished under construction building. And at least if there were any material to show that he was found with him sitting in that particular house on that day, I don't have any material, Your Honor. Last seen together theory can be proved. There is no such material to show that they were found together in that particular house. Now, coming to the background of this deceased, Your Honor. Deceased had many enemies. In fact, his own brothers were grinding acts against him, Your Honor, because he had sustained. He had taken loan of 8 lakh rupees and spent it on his vices, and he could not repay the amount to the society. Society was about to auction his 6 acres of land, and that amount was in fact paid by his brother's wife, and that auction was halted or stalled. Now this petitioner had a quarrel with his brother's wife, and he had come out and he was living in Shira. And second thing is, my lord, he had tortured his first wife, and there was a complaint filed by the first wife. She was driven out along with 2 minor children. His first wife has filed a complaint against him, and he in turn he also has filed a counter case against the wife's father and also wife. That ended in an acquittal. Now, considering all these aspects, Your Honor, considering the background and considering the way in which the investigation has been done in this case, Your Honor, may kindly peruse the page number 40. page number 82. A photo of the deceased. The ligature marks found on the neck are clearly indicative of the fact that he was throttled by using a rope. Wherein the prosecution story is built up on that he was throttled by a towel. And moreover, Your Honor, that towel at least would have been produced before the doctor who has conducted the PM to get an opinion. That has also been, the police have failed to produce that ligature before the doctor deliberately. Because towel, from using towel, such marks could not happen. Deliberately, they have kindly peruse the PM report is at page number 106, my lord. And 6, the last page. Ligature material are not furnished by the police. The towel that could have been produced before the doctor and the police before filing the charge sheet ought to have been produced it and taken opinion of the doctor in that respect. But and it is also, Your Honor, found from statement of his own brother that he had contacted a second marriage. He had brought a girl to his house and living with her, stating that he is married to her, that particular lady, after driving out the first wife. So considering all these aspects, my lord, considering the investigation also, moreover, it is only depending on circumstantial evidence. There are no material eyewitnesses to show that the petitioner has committed this crime. My submission, my lord, under these circumstances, he is entitled for bail. He is in jail from 6 months.
Sir, yes. CW2?
Seen the decision near the bus stop at 7:30 p.m.
7:30?
PM.
Then
my lord, CW3 is the auto driver who took the decision, the present petitioner. Auto dropped on 8:30 p.m. It's the second not CW4, my lord. One of the friend of the present petitioner. He stated that, my lord, he gave the 2 packet biryani as per instruction of the present petitioner and gave it to the petitioner on 9 p.m. that night. And his witness clearly stated that, my lord, he along with the disease are present. They are together.
Both were together at 9 p.m.
Moreover, on the monetary statement of the present petitioner, the towel and the bloodstained cloths are recovered.
Towel and bloodstained cloth.
Towel also stained blood, my lord.
Towel.
Recovered on the instruction of this present petitioner. Moreover, the opinion of the doctor also provided.
Strangulation.
The strong material. The bloodstained cloths and towels are sent for a vessel. Report is awaited.
Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the victim had borrowed an amount of rupees 1,15,000 as loan from this petitioner, and he did not repay the amount. Hence, this petitioner was having grudge against the victim. That on 24/2/22, when the CW3 was driving the auto rickshaw, this petitioner took the auto from Shira to Javagondanahalli, and thereafter took the victim in the very same auto rickshaw and came back to Shira at 8:30 and took the victim near the tea shop and taken the biryani from the CW4. Thereafter, the petitioner took the victim in his motorcycle towards Green Park Hotel to site number 85, wherein unfinished construction was going on, and took the and quarreled with him and fisted on his face. And when he fell down, by using the towel, he committed the murder. The counsel appearing for the petitioner would submit that this petitioner is in custody from last 6 months, and case is rest upon the circumstantial evidence. This petitioner has been apprehended on suspicious circumstances. The counsel would submit that the towel was not sent to the doctor to get the opinion whether by using the said towel commit the murder, and only relies upon the last seen witnesses and no any sound circumstances against the petitioner to continue him in custody since investigation has been completed and charge sheet is also filed. Per contra, the counsel appearing for the state would submit that last seen witnesses statements are recorded. CW2 is none other than the brother of the victim. He had seen the victim as well as the petitioner at 7:30 p.m. The statement of auto driver in which the petitioner taken the victim statement was recorded, and at 8:30 the petitioner took the victim in the said auto rickshaw. The counsel also would submit that CW4 statement was given. He categorically says that this petitioner as well as the victim were together, and the petitioner took 2 biryani from him. That is at 9 p.m. The counsel also would submit that the bloodstained cloth as well as towel was also seized at the instance of this petitioner immediately after his arrest. Motorbike seize ಆಗಿದೆಯಾ? ಎರಡರಲ್ಲೂ ಅಕ್ವಿಟ್ ಆಗಿದೆ. ಆಯ್ತು. The counsel also submits that the motorcycle in which the victim was carried was also seized at the instance of the petitioner. The counsel also submits that the PM report is very clear that cause of death is on account of strangulation, and hence the seized articles, that is bloodstained cloth as well as towel, were sent to the FSL, and FSL report yet to be received. Having heard the respective counsel and also on perusal of material, case is rest upon the circumstantial evidence. When the case is rest upon the circumstantial evidence, court has to look into whether any sound circumstances are available or not. While considering the bail petition, court has to see the prima facie material available or not. The prosecution mainly relies upon the last seen witnesses. that is CW2, 3 and 4, who have made the statement that the victim as well as this petitioner were together in between 7:30 to 9 p.m. The very contention of the petitioner counsel that when the case is rested upon the circumstantial evidence, there is no any strong circumstances against the petitioner. The fact that after the arrest of this petitioner, bloodstained cloth and towel were seized at the instance of this petitioner, and the same also stained with blood. And the same is also sent to the FSL. And apart from that, the cause of death is also clear that due to strangulation, the victim lost his life. When searching the material available on record, when the last seen witnesses have seen the petitioner as well as the victim in between 7:30 to 9 p.m. And apart from that, the witnesses have categorically stated that from the shop of CW4, 2 biryanis are purchased by the petitioner, and also CW3 auto driver categorically made the statement that the petitioner only took the victim in the said auto rickshaw. When all these sound circumstances are found against the petitioner, and also the FSL report is awaited, at this juncture it is not a fit case to exercise the powers under Section 439 of CRPC in granting bail in favor of the petitioner. In view of the discussions made up by Parthipanan Gowda, bail petition is rejected. However, liberty is given to approach this court after the receipt of FSL report.
Another date here. Offense under section
430, 420, 420.
The facts of the case, Your Honor, they could come up the complaint of page number 18, Your Honor. From nurse complaint. ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ನನ್ನ ತಾಯಿಯವರ ಜೊತೆ ವಾಸವಾಗಿರುತ್ತೇನೆ. ಖಾಸಗಿ ಕಂಪನಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. ಹೀಗೆ ಸುಮಾರು 3 ತಿಂಗಳ ಹಿಂದೆ ನನ್ನ ಮೊಬೈಲ್ ನಂಬರ್ಗೆ ಅವರ ನಂಬರ್ನಿಂದ ಯಾರೋ ಕರೆ ಮಾಡಿ, ಅಣ್ಣ, ನಾವು ಹೊಸಕೋಟೆಯವರು, ಊರಿನಲ್ಲಿರುವ ನಮ್ಮ ತಾತನ ಮನೆಯನ್ನು JCB-ಯನ್ನು ಕೆಡವಿಸಿ ಹೊಸ ಮನೆಯನ್ನು ಕಟ್ಟೋಣ ಅಂತ ಮನೆಯನ್ನು ಕೆಡವಿಸುವಾಗ 2 ಮಡಿಕೆಯಲ್ಲಿ ಚಿನ್ನದ ನಾಣ್ಯಗಳು ಸಿಕ್ಕಿದೆ. ನೀವು ಅದನ್ನು ಮಾರಿಸಿ ಕೊಡಿ, ನೀವು ಅದರಲ್ಲಿ ಸ್ವಲ್ಪ ತೆಗೆದುಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದರು. ಆಗ ನಾನು ಮೊದಲು ನನಗೆ ಇದೆಲ್ಲ ಬೇಡಪ್ಪ ಅಂತ ಹೇಳಿದೆನು. ಆದರೆ ಆ ವ್ಯಕ್ತಿ ಮತ್ತೆ ನನಗೆ ಫೋನ್ ಮಾಡಿ, ನೀವು ಅರ್ಧ ಬೇಕಾದ್ರೆ ತೆಗೆದುಕೊಳ್ಳಿ, ನಾನು ಮೊದಲು ಒಂದು 20 ನಾಣ್ಯಗಳನ್ನು ತಂದು ಕೊಡುತ್ತೇನೆ, ಚೆಕ್ ಮಾಡಿಸಿ ನಂತರ ತೆಗೆದುಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದನು. ಆಗ ನಾನು ಆಯ್ತು ಎಂದು ಒಪ್ಪಿಕೊಂಡಾಗ ಹೀಗೆ ಸುಮಾರು 1 ವಾರದ ಹಿಂದೆ ನನಗೆ ಫೋನ್ ಮಾಡಿ, ಮುದ್ದಲಿಂಗನಹಳ್ಳಿ ಹೊಸಪೇಟೆ ರಸ್ತೆಯ ಮಾಗನಗುಪ್ಪೆ ಹತ್ತಿರ ಬನ್ನಿ, 50,000 ಹಣ ತೆಗೆದುಕೊಂಡು ಬನ್ನಿ, ಯಾರನ್ನು ಕರೆದುಕೊಂಡು ಬರಬೇಡಿ ಅಂತ ಹೇಳಿದರು. ನಾನು 50,000 ಹಣವನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋದೆನು. ಸುಮಾರು ಸಂಜೆ 6:30 ಗಂಟೆಯಲ್ಲಿ ಮಾಗನಗುಪ್ಪೆ ಹತ್ತಿರ I-20 ಕಾರಿನಲ್ಲಿ 2 ಅಪರಿಚಿತ ವ್ಯಕ್ತಿಗಳು ಬಂದು ನನ್ನ ಹತ್ತಿರ 50,000 ಹಣ ತೆಗೆದುಕೊಂಡು ನನಗೆ ಒಂದು ಚಿಕ್ಕ ಕವರಿನಲ್ಲಿ ಸುಮಾರು 20 ನಾಣ್ಯಗಳನ್ನು ಕೊಟ್ಟನು. ಹಾಗೂ ಇವುಗಳನ್ನು ಚೆಕ್ ಮಾಡಿಸಿ ನೋಡಿ, ಇನ್ನೂ ಬೇಕಾದರೆ ಕೊಡುತ್ತೇನೆ ಅಂತ ಹೇಳಿದನು. ನಾನು ಅವುಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಬಂದು ಹಾಗೆ ಇಟ್ಟಿದ್ದೆನು ಮತ್ತು ಅವರ ನಂಬರ್ ಅನ್ನು ಡಿಲೀಟ್ ಮಾಡಿದೆನು. ನಂತರ ದಿನಾಂಕ 8/5/2022 ಒಂದು ನಾಣ್ಯವನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋಗಿ ಅಕ್ಕ ಸಾಲಿಗರ ಬಳಿ ಚೆಕ್ ಮಾಡಿಸಿದಾಗ ಅದು ನಕಲಿ ಎಂದು ಗೊತ್ತಾಯಿತು. ನನಗೆ ಫೋನ್ ಮಾಡಿ 50,000 ಹಣ ತೆಗೆದುಕೊಂಡು ಚಿನ್ನದ ನಾಣ್ಯ ಎಂದು ಮೋಸ ಮಾಡಿ ನಕಲಿ ನಾಣ್ಯಗಳನ್ನು ಕೊಟ್ಟಿರುವ ಅಪರಿಚಿತ ವ್ಯಕ್ತಿಗಳ ಮೇಲೆ false complaint given by the complainant against the accused. FIR, the name of the accused is not considered. ಮತ್ತೆ ಇವರು ಅನ್ನೋನ್ ಪರ್ಸನ್ಸ್ ಯಾವುದೇ ರೀತಿ ಹಣ ಇಸ್ಕೊಂಡಿಲ್ಲ, ಮತ್ತೆ ಯಾವ್ದು ಚೀಟ್ ಮಾಡಿಲ್ಲ ಸರ್. ಫಾಲ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದಾರೆ, ಈ ಕಂಡೀಷನ್ ಇಂಪೋಸ್ ಮಾಡಿದ್ದಾರೆ.
ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಪೊಲೀಸರು, ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಪೊಲೀಸರು, ಅರೆಸ್ಟ್ ಮಾಡಿ ಅಲ್ಲೇ ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ಟೇಷನ್ ಬೇರೆ.
ಮತ್ತೆ 438 ಬರುತ್ತೆ.
ಅವರು 41 ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು ಬರ್ತಾರ 41 ನೋಟಿಸ್
ಅಲ್ಲ, ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರು ಅನ್ನೋದಕ್ಕೆ ದಾಖಲೆ ಇದೆಯಾ?
ಪಾರ್ಟಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರೆ PF ರಿಕವರಿ ಮಾಡಿದ್ದಾರೆ.
ಏನ್ರಿ ಮತ್ತೆ 438 ಹೆಂಗ್ ಮೇಂಟೈನ್ ಆಗುತ್ತೆ?
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವ್ದು FIR ಕಂಪ್ಲೇಂಟ್ ಮಾತ್ರ ಇದೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಹೌದಾ? ಮತ್ತೆ 438 ಮೇಂಟೈನ್ ಆಗಲ್ವಲ್ಲ?
ಪಾರ್ಟಿ 1 ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅಷ್ಟೇ, ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದ್ದಾರೆ ದಾಖಲೆ ಕೊಡಿ.
ಸರ್ ಅಮೌಂಟ್ ಇದುವರೆಗೆ ಬಂದಿದೆ.
5,000 ರಿಕವರಿನೂ ಆಗಿದೆ. ಮತ್ತೆ 5,000 ನಗದು PF
ಅರೆಸ್ಟ್ ಮಾಡಿ ಮತ್ತೆ ಸ್ಟೇಷನ್
ದಿನಾಂಕ 10/5/2001 ಕಾಲಂ 4ರಲ್ಲಿ ಕಂಡ ವಸ್ತುಗಳನ್ನು ಈ ಪ್ರಕರಣದ A1 ಮತ್ತು 2 ಆರೋಪಗಳು ಕೃತ್ಯಕ್ಕೆ ಉದ್ದೇಶಿಸಿದ ವಾಹನ ಮತ್ತು A1 ಆರೋಪ ಫಿರ್ಯಾದಿಯಿಂದ ಮೋಸದಿಂದ ಪಡೆದ ಹಣದಲ್ಲಿ ಉಳಿಕೆಯಾಗಿರುವ ನಗದು ಹಣವನ್ನು ಆರೋಪಿಗಳು ಹಾಜರುಪಡಿಸಿದ್ದನ್ನು ಪ್ರಕರಣದ ಮುಂದಿನ ತನಿಖೆ ಬಗ್ಗೆ ಪಂಚನಾಮ ಮೂಲಕ ಅಮಾನತುಪಡಿಸಿಕೊಂಡಿರುತ್ತೆ. ವೆಹಿಕಲ್ ಅಂಡ್ ಆಲ್ಸೋ ಕ್ಯಾಶ್ ಆಫ್ ₹5,000. FIR PF ಹಾಕಿದ್ದಾರೆ ನೋಡಿ. PF ನಂಬರ್ 34 of 2002. ವೆಹಿಕಲ್ ಇದೆ ನೋಡ್ರಿ. ಹೆಂಗ್ ಎಂಟರ್ಟೈನ್ ಮಾಡಕ್ ಬರ್ತ್ರಿ? 438 ಹೋಂಡಾ ಕಂಪನಿಯ ಒಂದು ಕಾರು 820 ಕಾರು ಸೀಜು ಆಗಿದೆ. 438 ಹೆಂಗ್ ಬರುತ್ತೆ? 5,000 cash and also a car was seized by drawing a measure. ನೋಡಿ ಇದೇನ್ ಮಾಡ್ತಾನೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. How it is maintainable? Once you have been released by the police after seizure of the car as well as the amount of ₹5,000. Note, third in part. Counsel for the petitioner seeks time regarding maintainability of petition. List this matter on day after tomorrow. Third in part ಆದ್ಮೇಲೆ next week ಇಲ್ಲ. ಈ ವಾರದಲ್ಲಿ ಯಾವತ್ ಬೇಕು ವಿಚಾರ ಮಾಡಿ ನೋಡಿ ಅಷ್ಟೇನೆ. ಕಾರು ಕಸ್ಟಡಿ ತಗೊಂಡಿದಾರಂತ 5,000 ದುಡ್ಡು ರಿಕವರಿ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನೋಡಿ. 21st. Previous. How long they were in the hospital? 4 days. Injury to any vital part? Vital part ಏನು?
Index finger. Another one is the
cause of death. Injury number: incised wound over the left upper back, measuring 10 centimeter into 3 centimeters. Cavity deep, extending to rib cage and intradural extension with pneumothorax. 1, 3 and 4 are previous in nature. 1, 3 and ಮತ್ತೆ chop wound, measuring ends 8 centimeter into bone deep, obliquely placed over the back of the mid palm arm, dorsal aspect with laceration of extensor carpi radialis brevis, extensor carp ulnaris. Another is 4, chop wound measuring bone deep. ಏನ್ರೆಲ್ಲ 10 ಇಂಚು 10 centimeter into 4 centimeters, obliquely placed over the left knee with tear of joint capsule. Discharge summary ಅಲ್ಲಿ ಇದ್ದಾರೆ ಇದ್ರಲ್ಲಿ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಕೊಡಿ. Unity Hospital discharge summary 24/6. 24/6 or 24? 31/5 ಅಂತ ಇದೆ ಹೇಳ್ರಿ. 31/6.
31/5.
5. The injury admitted on so and so 24/5 ಅದು.
ಹೌದು.
Lacerated wound over the posterior medial aspect of elbow right. Ida hospital ರೀ, ಇದು ಯೂನಿಟಿ ಹಾಸ್ಪಿಟಲ್. Both Lacerated wound over the posterior medial aspect of mid forearm. With injury to ECA. Index finger with skin in the tendon. Shed. Lacerated wound over the left knee with same difference. ಯಾವಾಗ ಅರೆಸ್ಟ್ ಆಗಿದ್ದಾವ? 26/5.
And there is no other criminal entities. The allegations are omnibus. There is no specific allegation against specific case. And the civil dispute, there is a financial transaction between number 1 and the complainant. And he has to return the injured has to return the money to the accused number 1. And there is a telephonic conversation between accused number 1 and this injured. And complainant is his father.
Why there was an enmity?
Enmity financial first page ಅಲ್ಲಿ last line. ನನ್ನ ಕೊನೆಯ ಮಗನಾದ ಕಂಪ್ಲೇಂಟ್ ಟೈಪ್ ಕಾಪಿಯಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್. ನನ್ನ ಕೊನೆಯ ಮಗನಾದ ಕೆಲವರಿಗೆ ವ್ಯಾಪಾರದಲ್ಲಿ ಹಣ ಕೊಡಲು ಮತ್ತು ಆತನಿಗೆ ಹಣ ಬರಲು ಇತ್ತು. ಈ ವಿಚಾರದಲ್ಲಿ ಸುಮಾರು 1 ವರ್ಷದಿಂದ ನೌಫಲ್ ಈಸ್ accused number 1 ನನ್ನ ಮಗ ರಮೀಜ್ನಿಗೆ, ದೊಡ್ಡ ಮಗ ಅರಿಫನಿಗೆ ಮತ್ತು ನನಗೆ ಮೊಬೈಲ್ ಕಾಲ್ ಮಾಡಿ ಅನೇಕ ಬಾರಿ ಹೆದರಿಸಿದ್ದು. ಇದೇ ವಿಚಾರದಲ್ಲಿ ಇವರಿಗೆಲ್ಲ ಅಡ್ಡಗಟ್ಟಿ ಹಿಡಿತವಾಗಿ ಎನಿಮಿಟಿ.
What is the Kerim? What is the vote act allegation against this petitioner? ಎಲ್ಲರೂ ಸೇರಿ weapons. What are the weapons are used?
2 weapons were recovered from one Aspak. There is no recovery from this petition. That Aspak name is not found in the FIR.
In complaint also his name is not found. Only Naufal, Talat, Asif, Kerim, Sajul. His name is there. Kerim, idarla. Abdul Kerim.
Recovery Aspak ಮೇಲೆ ತೋರಿ.
ಇವನ್ ಕಡೆ ಇನ್ನೇನು ರಿಕವರಿ ಆಗಿಲ್ವಾ?
ಡಿಮಾಂಡ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ 27/5ರಂದು ಆರೋಪಿ ಕೃತ್ಯಕ್ಕೆ ಹತ್ಯಾರವನ್ನು ತೋರಿಸಿದಾಗ ಹೇಳಿ ಆರೋಪಿಗಳ ಪೈಕಿ ಅಸ್ಫಾಕ್ ನನ್ನು ಸಿಬ್ಬಂದಿಗಳು ಭದ್ರತೆಯಲ್ಲಿ ಪಂಚಾಯತ್ದಾರರ ಜೊತೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಕೋಟೆಕಾರಮದ ಪನೀರ್ ಕೋಟೆಕಾರ ರಸ್ತೆ ಪೂರ್ವ ಬದಿಯ ರಸ್ತೆಯಲ್ಲಿ ದ್ವಿಚಕ್ರವನ್ನು ನಿಲ್ಲಿಸಿ ಸದರಿ ಆರೋಪಿ ಅಸ್ಫಾಕ್ ಅನ್ನು ತೋರಿಸಿಕೊಟ್ಟ ಸ್ವಯಂ ಆಕ್ಟಿವಾ ಮೊಬೈಲ್ ವಾಹನವಾಗಿರುತ್ತದೆ. ಬಳಿಕ ಅಸ್ಫಾಕನು ಅಲ್ಲಿನ ಪೊದರು ಜಾಗದಲ್ಲಿ ಹುಡುಕಾಡಿ ಆರಿಫ್ ಹುಸೇನ್ಗೆ ಹಲ್ಲೆ ಮಾಡಲು ಉಪಯೋಗಿಸಿದ 1 ಇಂಚ್ ಸುಮಾರು ಅಜಮಾಯಿಸಿ ನೋಡಲಾಗಿ 15 ಇಂಚು ಉದ್ದದ 5 ಇಂಚು ಇಡೀ ದೀರ್ಘ ಇರುವ 1 ಇಂಚು ಅಗಲ ಇರುವ ಒಂದು ತಲವಾರು, ಇದರಲ್ಲಿ ರಕ್ತ ಕಲೆಗಿರುತ್ತದೆ. ಇನ್ನೊಂದು 4 ಇಂಚು ಪ್ಲಾಸ್ಟಿಕ್ ಹಿಡಿ ಇರುವ 1 ಇಂಚು ಅಗಲದ ತುಪ್ಪಾದ ಒಂದು ಚಂದ್ರಾಕೃತಿಯ ಚೂರಿಯನ್ನು ವಶಪಡಿಸಲಾಗಿದೆ. That is from one Aspak.
But all were together at the time of seizure. All were only one.
ಆರೋಪಿಗಳ ಪೈಕಿ ಅಸ್ಫಾಕ್ ನನ್ನು ಸಿಬ್ಬಂದಿಯವರ ಭದ್ರತೆಯಲ್ಲಿ ಪಂಚಾಯತುದಾರರ ಜೊತೆಯಲ್ಲಿ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಕೋಟೆಕಾರ್ ಗ್ರಾಮದ ಪನೀರ್ ನೋಟಿಕಲ್ ಇರುವ ರಸ್ತೆಯಲ್ಲಿ ರಿಮಾಂಡ್.
ಬೇರೆ ರಿಕವರಿ ಇದೆಯಾ? ನೀವು ಓದಿದ ಯಾವ್ದ್ರಿ? ಅದ್ ಮಾಜರು 27/5 ರಿಮಾಂಡ್ ಅಪ್ಲಿಕೇಶನ್ ಬಟ್ ಮಾಜರ್ ಇದೆಯಲ್ಲ, ಮಾಜರ್ ಇದೆ. ಪ್ರಕರಣದ ತನಿಖೆ ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಆರೋಪಿಗಳಾದ ಅಸ್ಫಕ್, ನಿಶಾಕ್, ಮೊಹಮ್ಮದ್, ರಿಫಾತ್, ಅಲಿ, ಉಮರ್ ಫರೂಕ್, ಇರ್ಫಾನ್, ಅಬ್ದುಲ್ ಕೇರಿ ಎಂಬುವರನ್ನು ಈಗಾಗಲೇ ದಸ್ತಗಿರಿ ಮಾಡಿದ್ದು, ದಸ್ತಗಿರಿಯ ಸಮಯದಲ್ಲಿ ದಿನಾಂಕ 24/5/2001 ಬೆಳಗಿನ ಜಾವ ಕೋಟೆಕಾರ್ ಗ್ರಾಮದ ಅಜ್ಜಿನಡ್ಕ ಬಳಿ ಅರೀಫ್ ಹುಸೇನ್ ಅವರಿಗೆ ಹತ್ಯಾರನಿಂದ ಹಲ್ಲೆ ನಡೆಸಿದ ಹತ್ಯಾರಗಳನ್ನು ಮತ್ತು ಹತ್ಯಾರಗಳನ್ನು ಮತ್ತು ದ್ವಿಚಕ್ರ ವಾಹನವನ್ನು ವಶಪಡಿಸಿಕೊಳ್ಳುವ ಸಮಯದಲ್ಲಿ ಮಾಜರ್ ಪೊಲೀಸರು ಈ ಕೆಳಗೆ ಸಹಿ ಮಾಡಿರುವ ನಮ್ಮನ್ನು ಪಂಚಾಯತ್ಕಾರರಾಗಿ ಹಾಜರಿದ್ದು ಸಹಕರಿಸುವಂತೆ ಕೇಳಿಕೊಂಡ ಮೇರೆಗೆ ನಮ್ಮ ಪ್ರಕರಣದ ವಿಚಾರ ತಿಳಿಸಿ ಸೋನ್ಸು ಆರೋಪಿಗಳ ಪೈಕಿ ಅಂತ ಇದೆ ಅಲ್ರಿ, ಒಬ್ಬಂದೇ ಇದೆಯಲ್ರಿ. ಹಾ, ನಂತರ ಪ್ರಕರಣ ತನಿಖಾಧಿಕಾರಿ ಸೋನ್ಸೋ ಬುಳ್ಳಾಲ್ ರವರು ಪ್ರಕರಣ ದಸ್ತಗಿರಿಯಾದ ಆರೋಪಿಗಳ ಪೈಕಿ ಸೋನ್ಸೋ ಎಂಬಾತನನ್ನು ಸಿಬ್ಬಂದಿಯವರ ಬಟ್ the reference is arresting of all the accused persons, but regarding recovery is concerned only Aspak. ಕೋಟೆಕಾರು ಚಿಟ್ಟಿರಾಗ ತಿಳಿಸಿದಂತೆ ಸೋನ್ಸೋ. ಕೊಡಿ. The petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 24/5/2022 at about 7 to 7:30 a.m. when the first informant was in his workplace at Mangalore, Kamai's elder son, injured Arif Hussain, made a video call stating that on that day at about 6:30 a.m. when he was proceeding in the motorbike along with his relative Umar Farooq near Ajinadka Masjid, this petitioner along with other accused persons assaulted him with knife and also talwar. As a result, he had sustained bleeding injury. Immediately, the injured shifted to Unity Hospital, Mangalore. The motive for committing the alleged assault was financial dispute between the first informant's younger son and accused. That is
number 1.
Oh, there. Accused number 1. That is younger. That is accused number 1. The counsel appearing for the petitioner would submit that there was no any criminal antecedents against this petitioner, and only a general omnibus allegation is made against this petitioner and others that all of them joined together and inflicted injury with talwar and knife. The counsel would submit that only recovery at the instance of accused Aspak and not at the instance of this petitioner. The counsel also would submit that the injured was admitted to hospital on 24/5/2022 and he was discharged on 31/5/2022. And the injured is out of danger and this petitioner is in custody from 26/5/2022. And almost investigation has been completed and no need of further custody for further investigation. And hence he may be enlarged on bail. What about others?
Others having criminal antecedents.
The counsel appearing for the state would submit that the wound certificate discloses injury number 1, 3, and 4 are previous in nature. That is incised wound over the left upper back, measuring 10 centimeter into 3 centimeters, cavity deep. The injury number 3 is also a chop wound, measuring 8 centimeter into 6 centimeters, bone deep, obliquely placed over the back of the mid forearm. The other chop wound, measuring 10 centimeter into 4 centimeter, bone deep, obliquely placed over the left knee with theory of joint capsule. The counsel would submit that though other injuries are simple in nature, court has to take note of the gravity of the offense and also nature of injuries suffered by the injured. Though injured was discharged from the hospital on 31/5/2022, wound certificate clearly discloses there were 3 grievous injuries out of 7 injuries. and hence there is a prima facie case against the petitioner herein. Having heard the respective counsel and also on perusal of material, the material discloses that there was a financial dispute between the parties. And allegation is also that with an intention to take away the life came with knife as well as talwar and inflicted the injury. And as a result, there were 7 injuries are sustained by the victim. Out of that, 3 injuries are grievous in nature. The discharge summary placed by the petitioner counsel discloses the lacerated wound over the posterior medial aspect of elbow right, lacerated wound over the posterior medial aspect of mid forearm, and other lacerated wound over the index finger, and lacerated wound over the left knee with tear of joint capsule. And having taken note of nature of injuries sustained by the victim, though they are grievous in nature, and this petitioner is in custody from 26/5/2022, there are no any criminal antecedents against this petitioner. And also an omnibus allegation is made that they inflicted injury, that and there is no any specific overt act allegation against this petitioner. When such being the case, no need of further custodial investigation is required in respect of this petitioner in the absence of any other criminal antecedent, and hence the petitioner is entitled for bail with conditions. Who is Ashok Kumar Shetty? You are appearing. Huh? Yen along with. ಮೊದಲು ಬೇರೆಯವರು ಇದ್ರ ಅವರು ಇದ್ದಾರೆ along with that. Both are 438 or both are 438.
Petitioner in 6004 is accused number 2. FIR is at my lord page 10. Number
First petition 6255.
I am referring to 6004.
004. First one is A3, second one is A2. Page number?
The complaint is at page number 15. Here the sections invoked is 409 and 182A, 182B of Karnataka Land Revenue Act. Complaint is based on a plain reading of the complaint. It is dated 14/2022. The ಉಲ್ಲೇಖ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಚಿಕ್ಕಮಗಳೂರು ಅವರ ಕಚೇರಿ ಭೇಟಿ ಮೌಖಿಕ ಆದೇಶ 14/22. ಮಾನ್ಯ ಹಿರಿಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಉಪವಿಭಾಗ ಚಿಕ್ಕಮಗಳೂರು ಪತ್ರ 31/3/22. ಎಂ ಮಂಜುನಾಥ್ ಬೆಳ್ಳೂರು ವಾಸಿ ಇವರು ಪ್ರಾದೇಶಿಕ ಆಯುಕ್ತರ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಿದ 28/12/20. ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮೂಡಿಗೆರೆ ತಾಲೂಕು ಬಾಳೂರು ಹೋಬಳಿ ಬಾಳೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 168ರಲ್ಲಿ ತಲಾ ಹಲವರಿಗೆ ತಲಾ 4 ಎಕರೆ 38 ಎಕರೆ ಅಂತ ಅಕ್ರಮವಾಗಿ ಖಾಸಗಿ ವ್ಯಕ್ತಿಗಳ ಜಮೀನು ಮಂಜೂರಾತಿ ಮಾಡಿದ್ದು. ಈ ಬಗ್ಗೆ ಮಾಹಿತಿ ಹಕ್ಕು ಕಾಯ್ದೆಯಡಿ ಮಾಹಿತಿ ಕೋರಿದಾಗ ಯಾವುದೇ ಕಡತ ದಾಖಲೆಗಳು ಇಲ್ಲದೆ ಇರುವ ಕುರಿತು ಕಡತ ಸಂರಕ್ಷಣೆ ಮಾಡಲು ಕರ್ತವ್ಯದ ಪ್ರಯತ್ನಿಸುತ್ತಾರೆ ಎಂದು ಈ ಬಗ್ಗೆ ಕಡತ ಸಂರಕ್ಷಣಾ ಕಾಯ್ದೆಯಂತೆ ಸಂಬಂಧಪಟ್ಟವರ ಮೇಲೆ FIR ದಾಖಲು ಆದೇಶ ನೀಡಬೇಕೆಂದು ಮಂಜುನಾಥ್ ಅವರು ಉಲ್ಲೇಖ 4ರಂತೆ ಪ್ರಾದೇಶಿಕ ಆಯುಕ್ತರ ಕಚೇರಿಗೆ ದೂರು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಮಾನ್ಯ ಹಿರಿಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಉಪವಿಭಾಗ ಚಿಕ್ಕಮಗಳೂರು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಚಿಕ್ಕಮಗಳೂರು ಅವರ ಕಚೇರಿ ಭೇಟಿ ದಿನಾಂಕ 14/22ರಂದು ನೀಡಿದ ಮೌಖಿಕ ಆದೇಶದಂತೆ ಈ ಕೆಳಗಂಡ ಪ್ರಕರಣಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ 1964ರ ಕಲಂ 192A ಮತ್ತು B ಅನ್ವಯ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಲು ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ಕೋರಿದೆ. According to them, 11 persons were allotted land government land in survey number 168, my lord. Next para, page 16. ಈ ಪಟ್ಟಿಯಲ್ಲಿ ಖಾತೆದಾರರಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಮೂನೆ 50-53ರಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದು ಮತ್ತು ಯಾವುದೇ ಕಡತ ತಯಾರಿಸಿರುವುದು ಮತ್ತು ಅಕ್ರಮ ಸಕ್ರಮ ಸಮಿತಿಯಲ್ಲಿ ಮಂಡಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ ಮತ್ತು ಸಾಗುವಳಿ ಚೀಟಿ ವಿತರಣಾ ವಹಿಯಲ್ಲೂ ಸಹ ಯಾವುದೇ ಖಾತೆದಾರರ ಹೆಸರು ದಾಖಲಾಗಿರುವುದಿಲ್ಲ. ಮುಂದುವರಿದು RRT ಶಾಖೆಯಲ್ಲಿ ಸಹ ಭೂಮಿ ಶಾಖೆ ಕಡತ ವರ್ಗಾಯಿಸುವ ವಿಷಯದಲ್ಲಿ ಸದರಿ ಪ್ರಕರಣ ನಮೂದಾಗಿರುವ ಸಂಬಂಧಪಟ್ಟ ಶಾಖೆಯವರು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಆದುದರಿಂದ ಸದರಿ ಪ್ರಕರಣಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ RTC ಮತ್ತು MR ಮಾತ್ರ ಲಭ್ಯವಿದ್ದು ಬೇರೆ ಯಾವುದೇ ದಾಖಲೆಗಳು ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. ಸದರಿ ನೌಕರರುಗಳು ಅಕ್ರಮವಾಗಿ ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿ ಖಾತೆ ದಾಖಲಿಸುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ನೌಕರರುಗಳ ವಿರುದ್ಧ ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ ಅಧಿನಿಯಮ 1964 ಕಲಂ 192A ಮತ್ತು B ಅನ್ವಯ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ದಾಖಲಾಗಿದೆ. First is Mahesh H, who is a revenue inspector. The petitioner whom I am representing is he was a village accountant. I was also in charge revenue inspector Ish NS. Accused number 3, my colleague is my lord, prior to this,
revenue inspectors and village accountants.
Revenue inspector, village accountant in charge of computer has been implicated. Kindly peruse page 28, my lord. Annexure A2. In Annexure A2, page 29, according to the revenue records, my lord, the computer entry, the record of rights can be entered only with the prior permission and electronic signature of the Tahsildar. Village accountant has no locus or no right. Kindly peruse page 29, second para. ಮೇಲ್ಕಂಡ ಎಲ್ಲಾ ಪ್ರಕರಣಗಳಲ್ಲಿ ಅರ್ಜಿ ಇರುವುದಿಲ್ಲ ಹಾಗೂ ಬಕರೂಪು ಸಮಿತಿ ನಿರ್ಣಯವಾಗಿರುವುದಿಲ್ಲವೆಂಬುದಾಗಿ ತಿಳಿಸಿದಾಗ್ಯೂ ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಖಾಸಗಿ ವ್ಯಕ್ತಿಗಳಿಗೆ ಕಾನೂನು ಬಾಹಿರ ಮಂಜೂರಾತಿ ಈ ಕೆಳಕಂಡ ಅಧಿಕಾರಿಗಳು ಕ್ರಮವಹಿಸಿರುವುದಾಗಿ ವರ್ತಿಸಿರುತ್ತಾರೆ. Number 1, HM Ramesh, Tahsildar, Mudigere Taluku, working at the Revenue Secretary's office. Second one is Balaya, RRT Shirastena. He is in charge of all record of right entries in the entire Mudigere Taluku. And these two persons, the third one is Mahesh H. Fourth one is this petitioner. Fifth one is my colleague. Next is some allegations that they have leveled against the RRT entries against the accused number 5. But however, according to the revenue record, entire the Bhumi system has come for entries of RRT. And it has to be done with the prior approval of the Tahsildar alone. Village accountant has no local standing. In the instant case, they have in the complaint they states that Tahsildar, RRT Shirastedar and subordinate staff are in charge. But FIR has been lodged against the these 3 persons. The Tahsildar has been Shirastedar, who is presently working as grade 2 Tahsildar is land grabbing department. Presently, and even in the suspension order is only against these 3 persons, and that matter has been stayed by the JD. My humble submission here, the allegation, it is not 1 acre or 2 acre. 11 persons have been allotted the land according to them.
What is the total extent?
A total extent it comes to around 54 acres. 4 acres 38 guttas comes almost to 54 acres. And 11 persons have been allotted in the Their contention is no documents are available when the DC has inspected. An RTA application was filed by this one Mr. Manjunath from December till date. That file was not available for them. Later, the entries are made in RR and other mutation entries are available. Related documents and other forms are not available. And the allegation against the petitioner is that they have not protected the file. Kadatavana samrakshane madi. But however, the instant case, Tahsildar, then Shirastedar and other 3 persons are there. A plain reading of that, all these decisions could be taken only by Tahsildar and the movement. They are only like post office.
And all these decisions have been taken by the Tahsildar and above. And these petitioners have been implicated. And there is no prima facie any allegation against this petitioner who was village accountant. He is like a post office, he is provided. Decision has been taken by the Tahsildar and even the deputy commissioner who visited the office not passes a written order. Maukhika Adesha Mata. And even suspension order which the KAT has stayed, my lord, there too they make a reference about the page 29 about the Tahsildar and RRT Shirastena. And suspension has been only these three lower level officials are recipients of suspension. In the misadventure of protecting the Tahsildar, I have been implicated here, my lord. And time and above this court has come out about the thing and gave the order of staying the suspension of these petitioners. Also, I am bringing to the notice of your lordship. And however, in the identical situation, the law laid down by this honorable court. Petitioner is I leave it to the collective wisdom of this honorable court. The plain reading of the paper. Even the allegation against that RRT entry village accountant could be done only after giving the digital permission from the Tahsildar and RRT. No, according to the revenue of this thing, everything has to be done by Tahsildar alone.
Whose instance these entries are made in the revenue records. RTC nallalli entry agidiyalla, even mutation entry agidiyalla, who made those entries? Accused number 3. Who is that petitioner? Revenue inspector. Village accountant. Entry yaar matrodu? A3 na? A3 andre petitioner yaru? NN Girisha athava Geeta na? Geeta. Now petition by Geeta and Girish. They are the accused number? A1 custody ಇದೆ. Any have you got document making an entry in the revenue records, RTC and idರಲ್ಲಿ? Now according to him there are entries in the revenue RTC as well as mutation. Who entered? Who made the mutation entries and also the RTC entries? There must be some document to ಬಂದಿಲ್ವಾ documents in that is the main in the absence of any grant, what is the basis for making an entry? You get the records. Let him get an authenticated document. Elli ಯಾವ ಊರಿದು? ಚಿಕ್ಕಮಗಳೂರಾ?
I draw your attention to page 30 of my petition. 30th petition. ಕೆಲ್ಕಂಡ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ತನಿಖಾ ವರದಿ ಹಾಗೂ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಮೂಡಿಗೆರೆ ತಾಲೂಕು ಬಾಳೂರು ಮುನ್ಸೂಚನಾ ಖಾತೆಗೆ ತಲಾ 4 ಮಂಜೂರಾತಿ ನಿಯಮಗಳನ್ನು ಅಕ್ರಮವಾಗಿ ಮಂಜೂರು ಮಾಡಿ ಖಾತೆ ದಾಖಲೆ ಮೇಲ್ಕೊಂಡಿದೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಮೂಡಿಗೆರೆ ತಾಲೂಕು ತಹಶೀಲ್ದಾರ್ ಷರತ್ತುದಾರ್ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಮತ್ತು ಗ್ರಾಮ ಲೆಕ್ಕಕರು ತಂಡವಾಗಿ ಕೆಲ್ಕಂಡ ಎಲ್ಲಾ ಪ್ರಕರಣ
all are joined together ಅಂತ ತಂಡವಾಗಿ ಅಂದ್ರೆ that is
but the Karnataka Land Revenue Act says because of Tahsildar is a custodian of the entire revenue document and the entire government land in the revenue taluk. Tahsildar is
ನಾವು ದೊಡ್ಡವರ ಬಗ್ಗೆ ಮಾತಾಡಂಗಿಲ್ಲಲ್ಲ ಈಗ. Only
opinion regarding corruption.
Now your argument is not touching not touch the higher officers.
Oh my God. Time and again, this court has observed about the highly placed and lowly placed people. How lowly placed people have been made a scapegoat regarding the general opinion
But
perception.
we have to see only the case.
Not as per the corruption is a social menace, but small fishes have been duplicated. Poor lady has.
ಈಗ ನಾವು only ಬರೀ small fishes ಮಾತ್ರ ನೋಡ್ಬೇಕು.
Even the poor lady, only water coming.
You get the records, you get the records. ಆಯ್ತಾ, who made an entries in RTC as well as the mutation. There must be some document for having granted the land. ಆತರದಿಲ್ಲ ಅಂತ. But without any documents, how make an entry in the revenue records? You get that record. ಹೇಳಿ madam. What is that? Any document with regard to the making of entry in RTC as well as ಆದೇಶ ಅದೇ ಯಾವತ್ ಮಾಡಿರೋದು ಮ್ಯೂಟೇಶನ್ ಎಂಟ್ರಿ? ಆಯ್ತು, you get the records. I will give you 2 days time. Day after tomorrow, you get the records. Third in part, HCGP seeks time to get the records regarding entries made in RRT, RTC, and also in the mutation register. This matter day after tomorrow. Kodi. Or a copy kodi other side. The counsel appearing in criminal petition number 6255 of 22 filed memo along with additional documents and the same taken on record. Madam, only person who has made the entries in the RTC as well as the mutation without any sanction order or grant order, how can make such an entry?
The entire, this is pertaining to 54 acres of land in a entire file may be summoned, my lord.
ನಾವು ಸಮ್ಮನ್ ಮಾಡಂಗಿಲ್ಲ, ಯಾವ್ದು ಮುಟ್ಟಂಗಿಲ್ಲ. ನಾವು ಬರೀ ನಮ್ಗೆ ಏನ್ ಮೆಟೀರಿಯಲ್ ಇರುತ್ತೆ ಅದ್ ಮಾತ್ರ ನಾವು ಮಾಡೋದು.
Whatever documents are produced, my lord, myself and my colleagues have already.
That's why let him get the records. Let the government advocate get the records. Right, madam, land of 54 acres, not 1 or 2 acres of land. There are land of 54 acres of land, and without any sanction order and also without any grant order, if they makes any entry in the revenue records, it is the duty of the state also to protect the property of the state.
RRT Shirastedar are not accused. Villagers don't let revenue inspector and poor lady.
ಅಲ್ಲದೆ ನೀವ್ ಯಾರು ಅಕ್ಯೂಸ್ ಬಂದವರಲ್ಲ ಅವ್ರ ಬಗ್ಗೆ ಮಾತ್ರ ಹೇಳ್ಬೇಕು ಅಂತ. ಈಗ ನಾವು ಅದನ್ನೇ ಕೇಳ್ಬೇಕು ಅಷ್ಟೇ. ಆಯ್ತು, ಕೇಳೋಣ.
I endorse the rules about corruption in this honorable. But this case, I believe Gurigere is one of the costliest agricultural lands available in the state of Karnataka. So 54 acres is a serious matter. But how Tahsildar and Shirastedar have absorbed by the Deputy Commission's oral order. Here poor fellows have been implicated. Is a classic example. Without a digital thing, no entry can be made.
Things are going on like that. Right, you get the records. This matter day after tomorrow. 21st. Right, 21st. 2:30 at 2:30. 58. 2:30 madam, maintainability na idana. Conversion only na. Memo of petitioner counsel has filed memo for conversion of this petition as criminal appeal. Permitted to convert the same. For the statistical purpose, petition is disposed of. Criminal petition is disposed of. ಎಷ್ಟು ಪಾಸ್ ಅವರ್ ಆಗಿದೆ ಮೇಡಮ್ ಇದೆಯಾ 33 230 ತಗೊಳ್ಳೋಣ
3 days.
33 ತಗೊಳ್ಳಿ ಮೇಡಮ್. Petitioner counsel seeks again 3 times time. And hence list this matter on 22nd. 22nd or 21st second. 21st. ಅಲ್ಲ ಅದು ವೀಕೆಂಡ್ ಆಗ್ಬಿಡುತ್ತೆ ಬೇಡ 21st ಒಳಗೆ ತರಿಸ್ಬೇಕು. ಆಯ್ತು 22nd ಜಸ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲಲ್ಲ ಪಾಠಾಡಿರ್ಬೇಕು ಅವ್ರು ಪಾಠಾಡಿ.
I think another,
22nd.
according to my research, there is something fishy in this. This scapegoat goes to complainant and the accused.
What we'll say, only we'll talk about material. Material only. Point out, that's all.
Very, very bad case for me.
Bad or good, we'll decide. If you are having case, we'll decide. If you are having merits, we'll consider. ಹ್ಮ್
ಒಬ್ರಿ ಸರ್ ಒಬ್ರಿ
ಹೌದು.
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
Yes, sir. Yes, sir.
One second ಇದೆ.
benchmark.
Question.
Office objections are either order.
Notes, I have complied the office objection notes. I have served the copy upon the petitioner counsel notes.
Two affidavits are filed, same may be clarified. Some clarification?
One application along with affidavit filed under section 301 seeking notes permission, leave of the honorable court to assist the prosecution, and another affidavit not stating that the petitioner and the victim are now willing to marry, and even she is willing to marry. An affidavit is filed. Notes.
That is affidavit filed by whom?
By the victim, notes, the complainant victim, notes.
Victim. Yes, Councillor.
For the petitioner, successive petition notes. Earlier, this honorable court was rejected the prayer of the petitioner for bail. However, notes while disposing of the petition.
Whether that application is considered or not, your 301 application.
Well, it is not yet to be considered.
And then you make submission first on IA. First on IA.
Yes, Lord.
You will be allowed to assist to the HCGP, that's all.
Yes, Lord.
Good. Or the petitioner counsel and also the counsel appearing to the state as well as de facto complainant counsel. The de facto counsel, de facto complainant has filed an application 301 within bracket 2 of CRPC, saying this court to permit the counsel engaged by the complainant to assist the prosecution for effective disposal of the case. In support of an application, an affidavit is also filed. wherein sought for permission to assist the court through a government advocate for the reasons mentioned in the application and affidavit. IA is allowed, permitted to assist the HCGP, and accordingly IA is disposed of. Next, now on merits.
Number 45 earlier rejection order was
45.
was considering the submission that was both the petitioner as well as the complainant, their marriage was fixed, but due to lockdown was not solemnized. And in the meantime, this offense has taken place. Considering this submission, Lord had directed the trial court to dispose of the trial within a period of 3 months. This order was passed.
Within term of period of 3 months. What happened?
These E-Drill 1 and 2 have been examined. Now, next date is fixed on 20th of July this month.
20th of July.
This is one ground. And second ground, there is the both petitioners.
Whether they have sought any extension of time from this court?
So far, no.
Because order was passed on 14 January 2022. Already 3 months time was expired. Whether trial court sought any extension of time? No.
Both the petitioner and the complainant, with the intervention of Lord's family and friend, now they are willing to marry Lord. That effect, an affidavit is also filed by the Lord's complainant. So my prayer is that Lord's both.
Complainant is filed. What about the petitioner?
Petitioner, no, ನಾನು ready. ನಾನು petition ಅಲ್ಲೇ ಬರ್ತೀನಿ. ಮದುವೆ ಆಗ್ತಾ ಇದೀವಿ ಅಂತ ಹೇಳಿ. ಮದುವೆ ಫಿಕ್ಸ್ ಆಗಿತ್ತು. Due to lockdown, Lord's it could not be solemnized. And in the meantime,
where is the government in the petition?
Lord, sir.
Regarding marrying her.
Case number 4, Lord, sir. Paragraph 12.
Paragraph number 12.
ಯಾಕಂದ್ರೆ ಮದುವೆ ಆಗಿ ರಿಪೋರ್ಟ್ ಮಾಡ್ತೀವಿ. ಯಾರ್ ರಿಲೇಟಿವ್ಸ್.
Disposal within 3 months. Now it is not disposed of. Another 1 month al ಮುಗಿಸ್ಬಿಡಿ. Why we have to?
25 ಮಂದಿ ವಿಟ್ನೆಸಸ್ ಇದ್ದಾರೆ.
25 ಏನ್ ಬರ್ತದ್ರಿ ಈ ಕೇಸಲ್ಲಿ?
25
376 ಇದೆ. Only witnesses, main doctor evidence. Main witnesses ಅಷ್ಟೇ. Medical evidence and also the victim evidence.
ಜನವರಿಯಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿ.
ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅವ್ರು ಬಿಡ್ತಾರ ಬೇಕಾಗಿ ಬೇರೆಯವ್ರನ್ನೆಲ್ಲ ನಾಟ್ ನೆಸರಿ ಅಂತ ಇಲ್ರಿ. 2 months already 3 months ಕೊಟ್ಟಿದೀವಲ್ಲ. Already 3 months, but now we almost 7 months ಆಗಿದೆ. No extension of time. Why you are not supporting the assisting the court? January ಅಲ್ಲಿ ಹೋಗಿದ್ರಿ. ಏನ್ ಕೋವಿಡ್? ಈ ವರ್ಷದಲ್ಲಿ ಏನ್ ಹೋಗಿದ್ರಿ?
ಅಲ್ಲ, ಇದನ್ನ ಈ ಸಬ್ಮಿಷನ್ ಅನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿ ನಾವು ಟೈಮ್ ಲಿಮಿಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತೀವಿ.
Earlier submission ಅದೇ ರೀತಿ ಇತ್ತು. That is the reason only 3 months time was given.
Since it has not been done, and having regard to the facts and circumstances of the case, and the grounds are, was no useful purpose would be kept. Sir, you are taking the petitioner.
Learned counsel appearing for petition and also the learned counsel is also while the application for assisting the state submit that there is a likelihood of performing marriage between the two and the same may be considered.
Consider time limit
time ಆಗಿಲ್ವಲ್ಲ within time ಅಲ್ಲಿ another 2 months ಕೊಡೋಣ ಬಿಡಿ. In the meanwhile that time complete it. Another 2 months or 1 month ಏನ್ರಿ? We want 2 months. Already CW 1 and 2 are examined. You examine the doctor.
The victim was not examined. Other day 164 statement ಇತ್ತು.
Victim not examined.
On that day it was, now 20th she's matter is posted, they'll examine her on that day.
Another 2 months and we might court. And the petitioner counsel and also the counsel appearing for the state. This is a successive bail petition filed by the petitioner before this court. This court earlier had order dated 14th day of January 2022, in criminal petition number 201709 of 2021, rejected the bail petition. However, the respective counsels are directed to assist the trial court in disposal of the case within a time-bound period of 3 months. In view of the submission noted in paragraph number 9 of the order, the counsel appearing to the petitioner would submit that the trial is not yet over and only 2 witnesses are examined, and the counsel appearing to the state also not discuss the fact. The counsel appearing to the state would submit that within 2 months they are going to complete the trial. And this court earlier on merits dismissed the bail application, and having taken note of the reasons assigned in paragraph number 8 of the order, as well as the submission noted in paragraph number 9, and the concerned court also not sought any extension of time. However, taking into note of the affidavit filed by the complainant before this court, and also the petitioner counsel in paragraph number 12 of the order, 12 of the petition, due to some persons ill-advised, the petitioner had earlier refused to marry, but now, due to intervention, reconsidered his decision and going to marry the complainant. Having taken note of said facts into consideration and also the material on record, and already this court has given time-bound stipulation to dispose of the matter within 3 months, but the same has not been given effect, and hence it is appropriate to grant another 2 months from today to dispose of the matter, and both the petitioner counsel and also the counsel appearing to the state are directed to assist the trial court in disposal of the case within the time-bound period. The trial court is also directed to dispose of the matter within the said period, taking up the matter on regular basis. ಇನ್ನೊಂದಿರ್ಬೇಕಲ್ಲ 230 ಮ್ಯಾಟರ್.
Have a copy of the order. Instructions are not that the Honorable Supreme Court Court has stayed the orders not been challenged. So for a remarks and other things, pre-reports, etc. For the main matter is concerned, but there is no interim order. The court has to consider not the matter on the bail petition.
What is the main prayer?
There is bail, what is this?
Bail.
What is the main prayer?
Main prayer is the
SLP
SLP.
Challenging the order that are passed not on 7th of July.
7th July.
The order that has been passed, but of course I don't have a copy of the order. But my instructions are not also that is available in live law and other websites. Shows that not.
That is observation is stayed. What I
observation and that
noticed also.
Anything which is unconnected with the bail petition not has been stayed.
Yes, ready na ಏನು ಆರ್ಡರ್ ನೋಡ್ಕೊಂಡು ಕೇಳೋಣ. ಆರ್ಡರ್ ಬಂದ್ಬಿಡ್ಲಿ. tomorrow or day after tomorrow?
Day after.
Wednesday ಇನ್ನೊಂದು ಯಾವ್ದು ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಮೇಡಮ್? PSI ಮಾಡ್ತಿದ್ದೀರಾ? PSI matter ಇದೆ ಅದು ಪಾರ್ಟೆಡ್ ಅಲ್ಲ, ಆಲ್ಮೋಸ್ಟ್ ಆಗಿದೆ ಅದು. ಓನ್ಲಿ ದಿ HCGP has to conclude SPP. ಅದು one man petition ಅಲ್ಲಿ ಮಾತ್ರ ಮಾಡಿದ್ರೆ, ಇನ್ನು another 4 petitions we has to complete. ಹಾಕೊಂಡು ಅವತ್ತಿಗೆ ಹಾಕೊಂಡ್ಬಿಡಿ ವೆಡ್ನೆಸ್ಡೇ. ಹೌದಾ? The counsel appearing for the respondent would submit that matter has come up before the apex court today, and interim order has been passed with regard to the order dated 7/7/22, and both counsel requests list this matter on 20th, and then list this matter on 20th. In the meanwhile, ನಮಗೂ ಕಾಪಿ ಬರುತ್ತದೆ, ಪ್ಲೇಸ್ ಮಾಡಕ್ಕೆ.
Order not says, because this is online, not to permit with this reading. I don't know what exactly was the order, but this is what
ಬರ್ಲಿ ಬಿಡಿ, ಹೇಗಿರೋ ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ತಾ ಇದೀವಲ್ಲ, ಪೋಸ್ಟ್ಪೋನ್ ಮಾಡ್ತಾ ಇದೀವಲ್ಲ. 28th ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಬರಲಿ.
Day of that order and what the court has said, not we stay proceedings like asking for service report, field summary report, observation of ACB, etc. Prima facie observation made were unconnected with the bail petition. The observations were not made within the ambit of the bail petition.
In live law na live law ದಲ್ಲಿ ಇದೆಲ್ಲ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಬರೆಯಕ್ಕಾಗಲ್ಲ.
Direct high court to decide the bail petition.
Interim order ಅಂತ ಅಷ್ಟೇ ಮೇಡಮ್. The apex court has passed some interim order, and hence this matter on 20th. 2:30 ಅದನ್ನು 2:30 ಹಾಕೊಂಡಿದ್ದೀರಾ? ಅದು ರೆಗ್ಯುಲರ್ ಅಲ್ಲೇ ಬರ್ಲಿ, ಬೆಳಗ್ಗೆ ಯಾರು ಮಾಡಿ ಅಷ್ಟೇ. ಲೆಟ್ ಇಟ್ ಕಮ್.
ಬರ್ರಿ, ಬೆಳಿಗ್ಗೆನೆ ಬಂದು.
You keep the advocate on record on that. First hour matters. Madam, serial number 10. First half to 30. The petition, this matter is called twice, and no representation by the petitioner counsel. This court-wide order dated 18/7/22, 11/7/22, granted 1 week time to comply with office objection on cost of ₹500. It is also made it clear that the cost not paid and office objections are not complied with. This matter today, and no complaints, and also not paid the cost. Hence, petition is dismissed for non-practice. Yes, counsel. Withdraw now. Stop. Petitioner counsel has filed the memo seeking permission to withdraw the petition, and in view of the memo permitted to withdraw. Okay. ಕೆಲಸ ಇಲ್ಲ ರೀ, ಇವತ್ತು ಏರ್ ಮಾಡಿ ಹೇಳಿ ಏನಿದೆ ನೋಡಿ. Petitioner counsel seeks time. List this matter on 26. What is? ಬರೋದೇ ಇಲ್ಲ ಅಲ್ರಿ ಇವರು. ಅವಳು ಆಟೋ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. ಬೆಳಗ್ಗೆ ಯಾವ್ದೋ ಒಂದು ಮೆಮೊ ಇತ್ತು, ಮೆಮೊ ಹಾಕಿದ್ರು. Learned counsel for the petitioner is absent. However, one more opportunity is given. List this matter on 18/7/22. ಏನ್ ಅಫೆನ್ಸ್ ಏನು? 406 420 ಇದೆ. Why is not coming? ಏನಿದು? ಬರೀ 20,000 10,000 ಎಲ್ಲ ಇದ್ದಂಗಿದೆ ಅಲ್ರಿ. 6 ಲಕ್ಷನಾ? The petitioner counsel This matter is called twice, in the early morning and also in the afternoon. And no representation. And perusal of the previous order sheet also, the counsel was absent. However, one more opportunity is given to the petitioner counsel. In spite of opportunities given, no representation again. This time, first time, last time, file objections. ಇನ್ನೊಂದು ಚಾನ್ಸ್ ಕೊಡೋಣ. Madam, no representation. In the ends of justice, one more opportunity is given. If counsel doesn't appear in the next date of hearing, matter will be dismissed for non-prosecution. List this matter on 22nd account. ಬೆಳಗ್ಗೆ 16 ಆಗಿತ್ತು.